Okay, so yeah, I'm in there now. You guys need to get by here. Okay, sorry. So I'm in there now and I should have. Okay. Now I need.
Yes, but. Yes, but. Can you do that for me? Different spots so you know it's gonna get. What do you? Here. Yeah. That's one thing.
I don't know where you went to.
He took it off.
Yeah. Yeah. I think so.
Yeah.
Is it working?
Well, I need it for a good signal.
You only hear what's around, you don't hear the rest of the word. That's why I need them to have all around. So I know what's coming in. Like everything we're saying right now on the feed, that's what people are hearing. Everything we're saying on the feed.
Want to pass? No more witnesses, so I'll just have to put it back to the next truck.
Okay.
There's 2 boxes back there.
Oh, back here already?
The back row has 2 boxes.
Oh, you got it.
Yeah. Then everybody will want to use it.
And somebody's gonna empty it.
I'm also the janitorial person, so the less I have in here, the less I have to take out.
That's true.
You ever heard of that camping, pack it in, pack it out?
Yeah, that's right.
Yeah, there you go.
Okay.
Okay. All right, please.
Thank you. Good morning. Thank you. Please be seated. All right, let's go on the record. We'll be in session in Mast v. Brashear, Nez Perce County case CV 35-23-195. Mr. Brashear, Ms. Brashear, Mast, the defendants are present at council table. Plaintiffs and their lawyers are present at the plaintiff's table. We are outside the presence of the jury. Anything that we need to take up before we bring back the jury?
No, Your Honor.
No, Your Honor.
All right, please rise for the jury. Go ahead and be seated. Thank you very much. I will note for the record, the jury has been returned. They appear to be properly seated. Will the parties stipulate the jury is returned and seated appropriately?
Yes, Your Honor.
Thank you very much. Ladies and gentlemen, welcome back. We appreciate you coming back this morning. Did we provide, do you have the jury instructions for the, okay. Would you please pass those out? What I am doing is I'm going to have my bailiff pass you a copy of the jury instructions that I'm going to be giving to you. They're lengthy, and I think that will help you understand why we needed to take a lengthy break yesterday. Yeah, yes, right? And this is why I didn't want you to be having to sit back there in that room while we work through this. So, but in any event, I'm having them provide you a copy of the jury instructions, and I'm going to provide those to you, after which the parties are going to be allowed to give their closing arguments. Now, if you'll note, instructions 1 through 6 I previously gave. So we're going to be started. Those are the ones that I gave to you before we started taking evidence. I'm going to start on instruction 7. Instruction 7. You have now heard all the evidence in the case. My duty is to instruct you as to the law. You must follow all the rules as I explain them to you. You may not follow some and ignore others. Even if you disagree or don't understand the reasons for some of the rules, you are bound to follow them. If anyone states a rule of law different from any I tell you, it is my instruction that you must follow. Instruction 8. As members of the jury, it is your duty to decide what the facts are and to apply those facts to the law that I have given you. You are to decide the facts from all the evidence presented in the case. The evidence you are to consider consists of sworn testimony of the witnesses, exhibits which have been admitted into evidence, and any facts to which the parties have stipulated. Certain things you have heard or seen are not evidence, including 1, arguments and statements by the lawyers. The lawyers are not witnesses. What they say in their opening statements, closing arguments, and at other times is included to help you interpret the evidence, but is not evidence. If the facts as you remember them differ from the way the lawyers have stated them, follow your memory. 2, testimony that has been excluded or stricken or which you have been instructed to disregard. And 3, anything you may have seen or heard when the court was not in session. Instruction 9. Evidence may be either direct or circumstantial. Direct evidence is evidence that directly proves a fact. Circumstantial evidence is evidence that indirectly proves the fact by proving one or more facts from which the fact at issue may be inferred. The law makes no distinction between direct and circumstantial evidence as to the degree of proof required. Each is accepted as a reasonable method of proof, and each is respected for such convincing force as it may carry. Instruction 10. Before deciding whether the plaintiffs are damaged in this case, you must first decide whether the defendants are liable under the claims made by plaintiffs. With respect to each defendant, the plaintiffs have asserted multiple claims. First, the plaintiffs have alleged claims of wrongful death, intentional infliction of emotional distress, negligent infliction of emotional distress, and civil liability for death by firearm against the defendant, James Brashear. Second, the plaintiffs have alleged claims of wrongful death and intentional infliction of emotional distress against the defendant, Rebecca Brashear Mast. I will now explain the elements and burdens associated with each claim. Instruction 11. When I say that a party has the burden of proof on a proposition or use the expression, quote, if you find, or quote, if you decide, close quote, I mean you must be persuaded that the proposition is more probably true than not true. This is the burden of proof that is to be applied to the plaintiff's claims for wrongful death, intentional infliction of emotional distress, negligent infliction of emotional distress, and civil liability for death by firearm. The plaintiff, Robert Mast, has alleged the separate claims of wrongful death against both the defendant, James Brashear, and the defendant, Rebecca Brashear Mast. The plaintiff has the burden of proving the following elements for each defendant. 1, that an actionable wrong was committed by the defendant against the decedent, and 2, that the same actionable wrong caused the decedent's death. Instruction 13. When the death of a person is caused by the wrongful act or neglect of another, his or her heirs or personal representatives on their behalf may maintain an action for damages against the person causing the death. In every action Under this section, such damages may be given as under all the circumstances of the case may be just. Under Idaho law, a parent is an heir able to maintain an action for wrongful death. Instruction 14. You are instructed that the defendant, James Brashear, in this case has been previously convicted in a criminal proceeding of the offense of voluntary manslaughter for causing the death of John Mast. In this case, the defendant's prior conviction for voluntary manslaughter conclusively establishes the following facts which you must accept as true. One, that the defendant, James Brashear, engaged in unlawful conduct that caused the death of John Mast. Therefore, for purposes of this case, you must find that the defendant, James Brashear, committed a wrongful act against John Mast, and that same wrongful act caused his death. You must determine what damages, if any, should be awarded to the plaintiff, Robert Mast, as a result of that wrongful death, based on the evidence presented in this trial. Defendant Rebecca Brashear Mast was not charged with or convicted of any criminal act relating to John Mast's death. Instruction 15. The plaintiffs Stephen Mast and Betty Troyer have alleged claims of negligent infliction of emotional distress against James Brashear. In order to establish a claim of negligent infliction of emotional distress, so that each plaintiff has the burden of proving the following elements. 1, a legal duty recognized by law. 2, a breach of that duty. 3, a causal connection between the defendant James Brashear's conduct and the plaintiff's injury. And 4, actual loss or damage. Additionally, there must be a physical manifestation of the plaintiff's emotional injury, which is designed to provide a degree of genuineness that claims of mental harm are not imagined. Instruction 16. The plaintiffs Robert Mast, Stephen Mast, and Betty Troyer have alleged separate claims of intentional infliction of emotional distress against both the defendant James Brashear and the defendant Rebecca Brashear Mast. In order to establish a claim of intentional infliction of emotional distress, the plaintiffs must prove that 1, the defendant's conduct was intentional or reckless. 2, the defendant's conduct was extreme and outrageous. 3, there was a causal connection between the defendant's wrongful conduct and the plaintiff's emotional distress. And 4, the emotional distress was severe. Unlike a claim for negligent infliction of emotional distress, which requires a showing of physical injury or manifestation, a claim for intentional infliction of emotional distress has no such requirement. Instruction 17. When I use the word negligence in these instructions, I mean the failure to use ordinary care in the management of one's property or person. The words ordinary care mean the care a reasonably careful person would use under circumstances similar to those shown by the evidence. Negligence may thus consist of the failure to do something which a reasonably careful person would do, or the doing of something a reasonably careful person would not do under circumstances similar to those shown by the evidence. The law does not say how a reasonably careful person would act under those circumstances. That is for you to decide. Instruction 18. It was the duty of the defendants before and at the time of the occurrence to use ordinary care for the safety of the plaintiffs. Instruction 19. The negligence, if any, of any one defendant cannot be charged against the other defendant. Instruction 20. Gross negligence is distinguished as a matter of degree from ordinary negligence. Gross negligence involves carelessness that is so great that there was not just an absence of the ordinary care that should have been exercised, but a degree of negligence substantially greater than that which would constitute ordinary negligence. Instruction 21. The words willful and wanton, when used in these instructions and when applied to the allegations in this case, mean more than ordinary negligence. The words mean intentional or reckless actions taken under circumstances where the actor knew or should have known that the actions not only created an unreasonable risk of harm to another, but involved a high degree of probability that such harm would actually result. Instruction 22. If the jury decides the plaintiffs are entitled to recover from the defendant for negligent infliction of emotional distress, intentional infliction of emotional distress, or civil liability for death by firearm, the jury must determine the amount of money that will reasonably and fairly compensate the plaintiffs for any damages proved to be caused by the defendant's negligence. The elements of damage the jury may consider are A, non-economic damages, 1, the nature of the injuries, 2, the physical and mental pain and suffering, past and future, 3, the impairment of abilities to perform usual activities, 4, the disfigurement caused by the injuries. 5, the aggravation caused to any pre-existing condition. B, economic damages. 1, the reasonable value of necessary medical care received and expenses incurred as a result of the injury and the present cash value of medical care and expenses reasonably certain and necessary to be required in the future. 2, the reasonable value of the past earnings lost as a result of the injury. 3, the present cash value of the future earning capacity lost because of the injury, taking into consideration the earning power, age, health, life expectancy, mental and physical abilities, habits, and disposition of the plaintiffs, and any other circumstances shown by the evidence. 4, the reasonable value of necessary services provided by another in doing things for the plaintiff, which, except for the injury, the plaintiff would ordinarily have performed, and the present cash value of such services reasonably certain to be required in the future. And 5, any other specific item based on the evidence. Whether the plaintiff has proved any of these elements is for the jury to decide. Instruction 23. If the jury decides the plaintiff is entitled to recover from the defendant for wrongful death, the jury must determine the amount of money that will reasonably and fairly compensate the plaintiff for any damages proved to be proximately caused by defendant's negligence. The elements of damage the jury may consider are 1, the reasonable cost of the decedent's funeral, 2, the reasonable value of necessary medical care and expenses incurred prior to the decedent's death, 3, the reasonable value to the plaintiff of the loss of the decedent's services, training, comfort, conjugal relationship, and society, and the present cash value of any such loss that is reasonably certain to occur in the future, taking into consideration the life expectancy of the plaintiff, the decedent's age and normal life expectancy, habits, disposition, and any other circumstances shown by the evidence. The plaintiff's loss of financial support from the decedent and the present cash value of financial support the decedent would have provided to the plaintiff in the future, but for the decedent's death, taking into account the plaintiff's life expectancy, the decedent's age and normal life expectancy, the decedent's earning capacity, habits, disposition, and any other circumstances shown by the evidence. Death is inevitable. Although the law compensates for the untimeliness of a death caused by another, no damages are allowed for grief or sorrow. There can be no recovery for any pain and suffering of the decedent prior to death. Instruction 24. Under Idaho law, a person who causes the death of another through the discharge of a firearm may be held civilly liable for damages. To establish civil liability for death by a firearm, you must find that the defendant James Brashear killed John Mast by discharge of a firearm. Instruction 25. You are instructed that the defendant James Brashear in this case has been previously convicted in a criminal proceeding of the offense of voluntary manslaughter for causing the death of John Mast. In this case, the defendant's prior conviction for voluntary manslaughter conclusively establishes the following fact, which you must accept as true. 1, defendant James Brashear caused John Mast's death. Therefore, for purposes of determining civil liability for causing death by a firearm, you must find that the defendant James Brashear caused John Mast's death. Your role as jurors is to decide whether defendant James Brashear caused John Mast's death by discharge of a firearm. If you find that he did, you must then determine the amount of damages, if any, that should be awarded to the plaintiffs based on the evidence presented during this trial. Instruction 26. By giving you instructions on the subject of damages, I do not express any opinion as to whether the plaintiff is entitled to damages. Instruction number 27. You may draw a negative inference if, in response to a question, a witness invoked the Fifth Amendment right against self-incrimination. Instruction 28. If plaintiff proves by clear and convincing evidence that the defendant's acts which approximately caused injury to the plaintiff were an extreme deviation from reasonable standards of conduct, and that these acts were performed by the defendant with malice, fraud, oppression, wantonness, or gross negligence, you may, in addition to any compensatory damages to which you find the plaintiff entitled, award the plaintiff an amount which will punish the defendant and deter the defendant and others from engaging in similar conduct in the future. Instruction 29. Punitive damages are not a matter of right, but may be awarded in the jury's sound discretion, which is to be exercised without passion or prejudice. The law provides no mathematical formula by which such damages are to be calculated, other than any award of punitive damages must bear a reasonable relation to the actual harm done, to the cause thereof, to the conduct of the defendant, and to the primary objective of deterrence. Instruction 30. When I use the expression proximate cause, I mean a cause which, in normal or probable sequence, produced the complained injury, loss, or damages, and but for that cause, the damage would not have occurred. It need not be the only cause. It is sufficient if it is a substantial factor in bringing about the injury, loss, or damages. It is not a proximate cause if the injury, loss, or damage would likely have occurred anyway. There may be one or more proximate causes of an injury. When the negligent conduct of two or more persons or entities contribute concurrently as to substantial factors in bringing about an injury, the conduct of each may be a proximate cause of the injury, regardless of the extent to which each contributes to the injury. Instruction 31. When I say a party has the burden of proof on a proposition by clear and convincing evidence, I mean you must be persuaded that it is highly probable that such proposition is true. This is a higher burden than the general burden that the proposition is more probably true than not true. Instruction 32. In this case, you will be given a special verdict form to use in returning your verdict. This form consists of a series of questions which you're to answer. I will read to you the verdict form now. Questions concerning wrongful death claim. Question 1. Did the defendant, Rebecca Brasher Mast, commit an actionable wrong against the decedent, John Mast, that caused John Mast's death? Answer yes or no. If you answered question number 1 yes, proceed to question number 2. If you answered question number 1 no, proceed to question number 3. Question 2. What is the amount of damages plaintiff Robert Mast is entitled to receive for the wrongful death of John Mast due to Rebecca Brasher Mast's wrongful act? Answer to question 2 is a blank to be filled in with an amount. Proceed to question 3. What is the amount of damages the plaintiff Robert Mast is entitled to receive for the wrongful death of John Mast due to James Brasher's wrongful act? Again, there's a blank. Answer to question 3, there's a blank to fill in an amount. Questions concerning intentional infliction of emotional distress claims. Question 4. Did James Brasher intentionally inflict emotional distress on Robert Mast? There's a space to answer yes or no. Question number 5. What is the amount of damages the plaintiff Robert Mast is entitled to receive for intentional infliction of emotional distress due to James Brasher's conduct? And there would be a blank in there to fill in an amount. And then proceed to question 6. Did James Brasher intentionally inflict emotional distress on Stephen Mast? Again, there's this place to answer yes or no. If you answered question number 6 yes, proceed to question 7. If you answered question 6 no, skip to question 8. Question 7, what is the amount of damages the plaintiff Stephen Mast is entitled to receive for intentional infliction of emotional distress due to James Brasher's conduct? Again, there is a space to fill in a blank. Proceed to question number 8. Question 8 is, did James Brasher intentionally inflict emotional distress on Betty Troyer? And there is a space to answer yes or no. If you answer question 8 yes, then proceed to question 9. If you answer question 8 no, then proceed to question 10. Question 9 is, what is the amount of damages plaintiff Betty Troyer is entitled to receive for intentional infliction of emotional distress due to James Brasher's conduct? And then there would be a space to fill in a blank. Proceed to question 10. Did Rebecca Brasher Mast intentionally inflict emotional distress on Robert Mast? And there's a space to answer yes or no. If you answer question 10 yes, then proceed to question 11. If you answer question 10 no, then skip to question 12. Question 11 is, what is the amount of damages the plaintiff Robert Mast is entitled to receive for intentional infliction of emotional distress due to Rebecca Brasher Mast's conduct? Again, there's a space to fill in a blank for an amount. Proceed to 12. Question 12, did Rebecca Brasher Mast intentionally inflict emotional distress on Stephen Mast? There's a space to answer yes or no. If you answer question 12 yes, then go to question 13. If you answer question 12 no, skip to question 14. Question 13, what is the amount of damages the plaintiff Stephen Mast is entitled to receive for intentional infliction of emotional distress due to Rebecca Brasher Mast's conduct? There's a space to fill in an amount, then proceed to question 14. Question 14, did Rebecca Brasher Mast intentionally inflict emotional distress on Betty Troyer? There is a space to answer yes or no. If you answered question number 14 yes, proceed to question 15. If you answered question 14 no, then proceed to question 16. Question 15, what is the amount of damages the plaintiff Betty Troyer is entitled to receive for intentional infliction of emotional distress due to Rebecca Brasher misconduct? There's a blank to fill in an amount, and then proceed to question 16. These are now questions regarding negligent infliction of emotional distress claim. Question 16, did James Brashear negligently inflict emotional distress on Stephen Mast? There's a space to answer yes or no. If you answered question 16 yes, proceed to question 17. If you answered question 16 no, proceed to question 18. Question 17, what is the amount of damages the plaintiff Stephen Mast is entitled to receive for negligent infliction of emotional distress due to James Brashear's conduct? And there's a space to answer that, fill in a blank, then proceed to question 18. Question 18, did James Brashear negligently inflict emotional distress on Betty Troyer? There's a space to answer yes or no. If you answered question 18 yes, proceed to question 19. If you answered question 18 no, proceed to question 20. Question 19, what is the amount of damages plaintiff Betty Troyer is entitled to receive for negligent infliction of emotional distress due to James Brashear's conduct? And there will be a space to fill in a blank, then proceed to question 20. Did Rebecca Brasher Mast negligently inflict emotional distress on Stephen Mast? And there's a space to answer yes or no. If you answered question 20 yes, proceed to question 21. If you answered question 20 no, then proceed to question 22. Question 21, what is the amount of damages the plaintiff Stephen Mast is entitled to receive for negligent infliction of emotional distress due to Rebecca Brasher Mast's conduct? There's a blank to fill in the line. Proceed to question 22. Question 22, did Rebecca Brasher Mast negligently inflict emotional distress on Betty Troyer? Answer to question number 22 is either yes or no. If you answered question 22 yes, proceed to question 23. If you answered question 22 no, proceed to question 24. Question 23, what is the amount of damages the plaintiff Betty Troyer is entitled to receive for negligent infliction of emotional distress due to Rebecca Brasher Mast's conduct? There's a line to fill in a blank. Proceed to question 24. And these are questions regarding civil liability for death by firearm. Question 24. Did defendant James Brashear kill John Mast by discharging firearm? And there's a place to answer yes or no. If you answered question 24 yes, proceed to question 25. If you answered question 24 no, proceed to question 26. Question 25, what is the amount of damages the plaintiffs are entitled to receive because John Mast was killed by the discharge of any firearm? And there's a space to enter a number. Then proceed to question 26. These are questions regarding punitive damages. Question 26, is plaintiff Robert Mast entitled to punitive damages for defendant James Brashear's acts? There's a space to answer either yes or no. If you answered question 26 yes, proceed to question 27. If you answered 26 no, proceed to question 28. Question 27, what is the amount of punitive damages Robert Mast is entitled to receive based on James Brashear's acts? There is a space to fill in a number. Proceed to question 28. Question 28, is plaintiff Stephen Mast entitled to punitive damages for defendant James Brashear's acts? There's a place to answer either yes or no. If you answered question 28 yes, proceed to question 29. If you answered question 28 no, proceed to question 30. Question 29, what is the amount of punitive damages Stephen Mast is entitled to receive based on James Brashear's acts? And there's a space to enter a number. And then proceed to question 30. Question 30, is plaintiff Betty Troyer entitled to punitive damages for the defendant James Brashear's acts? If you answered yes to question 30, proceed to question 31. If you answered no to question 30, proceed to question 32. Question 31, what is the amount of punitive damages Betty Troyer is entitled to receive based on James Brashear's acts? There's a space to answer that question. Then proceed to number 32. Question 32, is plaintiff Robert Mast entitled to receive punitive damages for the defendant Rebecca Brasher Mast's acts? Again, the space to answer either yes or no. If you answered question 32 yes, proceed to question 33. If you answered question 32 no, proceed to question 34. Question 33, what is the amount of punitive damages Robert Mast is entitled to receive based on Rebecca Brasher Mast's acts? And there's a space to answer that question. Proceed to question 34. Question 34, is plaintiff Stephen Mast entitled to receive punitive damages for the defendant Rebecca Brasher Mast's acts? There's a space to answer yes or no. If you answered question 34 yes, proceed to question 35. If you answered question 34 no, proceed to question 36. Question 35, what is the amount of punitive damages that Stephen Mast is entitled to receive based on Rebecca Brashear Mast's acts? There's a space to answer that question. Proceed to question 36. Question 36, is plaintiff Betty Troyer entitled to punitive damages for the defendant Rebecca Brashear Mast's acts? There's a space to answer either yes or no. If you answered question 36 yes, proceed to question number 37. If you answered question 36 no, you are done, and you should sign and date the verdict form and notify the bailiff you have reached the verdict. Question 37, what is the amount of punitive damages Betty Troyer is entitled to receive based on Rebecca Brashear Mast's acts? And there's a space to answer question 37. It will then read, you should now sign and date the verdict form appropriately and notify the bailiff you have reached the verdict. Take a drink here. In deciding this case, instruction 33, in deciding this case, you may not delegate any of your decisions to another or decide any question by chance, such as by the flip of a coin or drawing of straws. If money damages are to be awarded, you may not agree in advance to you may not agree in advance to average the sum of each individual juror's estimate as a method of determining the amount of the damage award. Question 34. Instruction 34. If it becomes necessary during your deliberations to communicate with me, you may send a note signed by one or more of you to the bailiff. You should not try to communicate with me by any other means other than such a note. During your deliberations, you are not to reveal to anyone how the jury stands on any of the questions before you, numerically or otherwise, unless requested to do so by me. Question 35. Instruction 35. I have given you the rules of law that apply to this case. I have informed you regarding matters that you may consider in weighing the evidence to determine the facts. In a few minutes, counsel will present their closing arguments to you, and then you will retire to the jury room for your deliberations. Each of you has an equally important voice in the jury deliberations. Therefore, the attitude and conduct of jurors at the beginning of the deliberations are important. At the outset of the deliberations, it is rarely productive for a juror to make an emphatic expression of opinion on the case or to state how he or she intends to vote. When one does that at the beginning, one sense of pride may be aroused and there may be reluctance to change that position, even if shown that it is wrong. Remember that you're not partisans or advocates, but you are judges. For you as for me, there can be no triumph except in the ascertainment and declaration of the truth. Consult with one another, consider each other's views, deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should only do so after a discussion and consideration of the case with your fellow jurors. And instruction 36, on retiring to the jury room, select one of your number as the presiding juror who will preside over your deliberations. An appropriate form of verdict will be submitted to you with any instructions. Follow the directions on the verdict form and answer all of the questions required of you by the instructions on the verdict form. A verdict may be reached by 3/4 of your number or 9 of you. As soon as 9 or more of you shall have agreed upon each of the required questions in the verdict, you should fill it out as instructed and have it signed. It is not necessary that the same 9 agree on each question. If your verdict is unanimous, the presiding juror alone will sign it. But if 9 or more, but less than the entire jury agree, then those so agreeing with will sign the verdict. As soon as you have completed and signed the verdict, you will notify the bailiff, who will then return you into open court. All right. And with that, I will now allow the attorneys and the parties time for closing arguments. Mr. Miller, you may proceed.
Thank you, Your Honor. Yes. So our agenda got logged out of Zoom while we were reading instructions. There we go. Okay, good morning, ladies and gentlemen. We have finally reached the end where we're going to turn this case over to you. And before we do that, it's pretty typical lawyers and cases to when we start the trial, as Mr. Hickey did, we tell you what we're going to tell you, and then we tell you, and now we tell you what we don't. So I'm just going to do a recap today since we've been at this briefing. I'm certainly not going to hit everything that we talked about. That would be silly. But I want to hit some important points in the next few minutes and just kind of trying to recap things for you as a way of helping you in your deliberations. So I've got a presentation I'd like to share with you. I'm going to walk through this with you. First of all, Mr. Hickey and I were talking last night and realized you've not had a chance to see who we've been talking about this entire trial. This is John Mast. This is John Mast in a moment of happiness and joy with his two kids, Shira and Sam. This really sums up who John Mast is. You heard lots of evidence talk about it again here in a minute, the loving father of John Mast was. And this is a really good representation of that. I also wanted to start with this because you might be wondering, it might be a little confusing to you, perhaps, I'm not trying to talk down to you, but wondering if this is a wrongful death case and a case of infliction of emotional distress, gun violence, and so on against these defendants, why in the world have we spent so much time talking about John Mast? And in particular, why has it felt like John Mast has been on trial this whole time? I've been wondering that. The answer is, that's not how this started. This started with a complaint filed by the plaintiffs alleging wrongful death against the defendants, alleging infliction of emotional distress against the defendants. The defendants, in their answer to the complaint, started rehashing and re-raising these allegations of sex abuse against John Mast. We felt like it was important to defuse those things. Frankly, to be totally candid with you, ladies and gentlemen, out of fear that that would confuse the issues here. Mr. Bashir had a criminal trial. He was charged with first-degree murder and was tried in August of 2023. In that case, to my understanding, I wasn't there, but to my understanding, they were allowed to bring up a lot of these allegations, and the family was not allowed to address them because the issue in that case was whether or not he was first-degree murder. They were allowed to throw a lot of mud against John Mast and create this idea that perhaps these defendants were acting in self-defense or something like that, which is crazy to me. And yet it worked because Mr. Bashir was only found guilty of voluntary manslaughter, a shock to most of those watching that trial. When he said this killing that he performed, that he executed, was premeditated. When he said that to the police. So, I'm just explaining this in case you were wondering, why have we spent so much time talking about John Mast? Why have we spent so much time talking about the sexual abuse allegations directed at John Mast when this is the case against these? That's the explanation. Just wanted you to be aware that's what we're doing. The reason we did it was because they brought it up again. We felt like we needed to diffuse it. The second reason is, to be honest with you, Mast family wanted an opportunity to clear John's name. That's really a big part of this trial. They knew that these allegations would be raised. And they wanted an opportunity to present the evidence that was not shared at the first trial that John Mast was innocent of all of those allegations. And we hope that we have presented that evidence to you sufficient to show you That is a non-issue, a non-starter, and has nothing to do with the issue of this trial. More importantly, John Mast was innocent. An innocent man when he was found dead. Ladies and gentlemen, my partner, Kevin, Mr. Hickey, told you in his opening statement, this is the case of desperation, deception, and death. Let's talk about the desperation for just a minute. It began with these false accusations against John. The picture I'm sure that you have gathered through these 3 days of trial is a soon-to-be ex-wife and an ex-wife, mother of these children, desperate not to protect her children, but to maintain power in the custody relationship. Presented evidence to you, we'll talk about it in a minute, of the avalanche of allegations that she was making against John Mast. Not because he had ever done anything, but because she wanted to maintain power and control. So her deception began making these false allegations in a desperate attempt to gain leverage in the custody. Totally baseless. You heard from Detective Hendricks. She had zero evidence of anything that John had done wrong. These allegations were found several times to be without merit. You have exhibits, you'll have exhibits in front of you in the jury room to remind you of evidence that was presented. Judge Rustad in North Dakota determined that there was no evidence that John had abused his kids. Detective Hendricks in North Dakota, who conducted a 1.5-year-long investigation, had no evidence that he had ever abused his children in any way. These were found several times to be without merit. She continued with her father plotting John's death and made several comments to others about killing him. James thought about killing John hundreds of times. He told Rebecca that he wanted to kill him on more than one occasion. And this escalated as they tried to stop the supervised visitation on, and I'm sorry, I got the date wrong, should be February 5th, 2021. No one that day here in Lewiston would interfere with Judge Rustad's court order, though, and they got angry and desperate. Rebecca testified here on the witness stand that she got frantic that day, frantic to stop this supervised visitation. Court ordered unsupervised visitation that John was granted because John had done nothing wrong. And the judge knew that those kids needed John in their lives, and John needed them in his life. And as a parent, he's entitled to that. The judge knew that. The judge investigated these claims and found that John was entitled to unsupervised visitation, ordered by a court. Rebecca was frantic to stop it that day. James promised his daughter, Rebecca, you saw him yesterday on video. You saw the only time he broke down talking about killing John Mast, the only time he showed any emotion in his description of killing John Mast was when he said, I promised my daughter that John would not get the kids. It's the only time. Let's look at the deception. Rebecca knew that her dad had said he had wanted to kill John before. You heard Ashley Weitha testify a couple days ago at one of these visitations when all of the Brashears were there together, as they often were. And her dad got angry about the visitation. You heard from Detective Hendricks a couple days ago how all three of the family were there when she told them the results of her 1.5-year-long investigation. She found nothing, and he got mad, banged her table with his cane, and made a threat against John. Ashley Weitha testified the same thing, that he made a threat against John. He said, I'm serious. Rebecca was there. She heard these things. James told Rebecca that day that he wanted to kill John. The day he did it, he told her, those were his words to Detective Hendricks, in a very calm demeanor. He told her that day he wanted to kill John. Rebecca knew that her dad always carried a gun. James told Rebecca that day he was going to go follow John. Rebecca did not warn John or even just stay silent. She took an affirmative step to email him to be there at 6 p.m. James then switched cars with Rebecca. He moved his gun to the Suburban. She was aware of all. She knew that he took her car. She knew that he moved his gun because she was outside when it happened. That came out on Mr. Hickey's exam load for sheer mask. He left for Rosar's before Rebecca. He texted his wife when it was over. It's done. They continue today to insist that Rebecca had nothing to do with this killing. The evidence says otherwise. This was an evil web. An evil web of deception that was carried out to its final conclusion, the killing of John Mast in cold blood. It culminated in his violent murder. The deceit continued. Rebecca lured John to Rosar's, either in a calculated effort by sending that email or a simple act of gross negligence, given all that she knew. She knew that James took her car with the gun. James then laid in wait for John. He approached John in a friendly manner to catch him off guard. He had his gun hidden behind his back intentionally. You know, we didn't hear a whole lot about this. I thought that we would hear Mr. Brashear brag about his military background. He did in his criminal trial. I thought that he would talk about it. Instead, you heard what he said. But unlike a trained military person, unlike an honorable person who has served in the military, unlike anything like that, someone who might approach John and simply have a verbal argument with him and explain, I'm really angry at you. You shouldn't have these kids. No. Nothing like that. Nothing honorable is what he did. He didn't even come up and approach John and say, let's fight. Or say, hey, John, and have his gun out. He walked up in stealth with the gun behind his back, caught John off guard, and didn't even wait for John to react. Hey, John. John turns around, boom. As James said, right in the chest. Got it for sure. John was fixing car seats for his kids. That is unbelievable. These two people who claim they love these kids, John is trying to make his car safe for those kids that they claim to love. And James murders their father as he's making the car safe for them. That is unbelievable. James shot him once in the chest from just 4 feet away. Talk about dishonor. That's not enough. 4 feet away in the chest. That's not enough for him to just walk away and leave it. That would have done the job. No, he shoots him in the back like a craven coward. A coward. He was blinded by rage. He told police it was premeditated, and he doubled down and he said, I'm glad I killed him. I hope I killed him. Ladies and gentlemen, I want to talk about some of the things that were brought up in the jury instructions, and you'll have those, you have them now, you'll have them in the jury room. I'm not going to go through all these again, of course, but I want to talk about the burden of proof in this case and what that means. Who has the burden of proof? It's in the instructions. We do. The plaintiffs have the burden of proof. We accept that. That means we have to prove the case to you. It also means the defendants don't have to prove it. We have to prove to you. Now, what is the burden of proof? We didn't talk about this in voir dire. I could have brought this up, or maybe we didn't. I could have talked about this a little bit, but in court, we have 3 different burdens of proof. 2 of them are at play today. As we talk about. The first one is the basic burden of proof in a civil case, which is called preponderance of the evidence. So what is that? First of all, we have it. What is that? What does that mean? What does preponderance of the evidence mean? Well, it simply means more likely than not. More likely than not. So if we prove our case today on all of these things that the judge just went through with you, that long verdict form, all of those questions you have to answer, if we prove most of those to a degree of more likely than not, then we've proven our case to you. Now, what does that mean? More likely than not? Make it a little simpler for you. It's a pretty low standard. It's just 51%. If we prove to you that 51% we're right, that's enough. Now, that's contrasted by the burden of proof in a criminal trial. The burden of proof in a criminal trial, as many of you know, I'm sure, is beyond a reasonable doubt. That's a really high standard. That's like 95%. You got to be 95% sure that a person is guilty before you vote. That's a high standard. We're talking about preponderance of the evidence. In a minute, we're going to talk about clear and convincing, which is something between our back. But for most of the claims here today, it's preponderance, 51%, the lowest standard. That's all you've got to be persuaded. So let's talk about plaintiff's evidence for a minute. Again, I'm not going to hit everything that we covered. I just want to hit some highlights real quick. I want to talk about Betty, Stephen, and Robert together for just a minute. You heard from all of them that they are a very close-knit family, that John was a huge part of that family. John was a gentle soul with a great sense of humor. He was very close with all his siblings and his parents throughout his life. He was a hard worker. He worked for Praxair from 2012 to 2019. Now, the importance of that is we had anticipated, frankly, more evidence coming forward from the defendants, accusations against John that he had an alcohol problem, that he was an alcoholic, that he was a terrible father and unfit because he had these alcohol issues. We thought we'd hear more of that, so we put on, again, proactive evidence to show you that he had a CDL license, commercial driver's license, during that time period. And what that means is that he was subject to regular drug and alcohol testing. If he had an alcohol or drug problem, he would not have been allowed to work for Praxair, driving those vehicles, transporting oxygen for 7 years. He had no drug or alcohol issues. They talked about, all three of them talked about how much John adored his kids, Shira and Zane. They adored him until the brainwashing. Heard about the visits initially, heard from Ash and Louisa, were great. They were wonderful. They had wonderful visits. John was attentive to their needs. And then you heard how things started to change over time. Kids started to distance themselves and say, Mommy says I can't touch you. Leave me alone. This brainwashing was occurring behind the scenes because John had very little time with those kids. But he did love spending time with his kids any chance he got. He also tried to keep his parents and siblings involved in their lives as well, because family is very important to them. The plaintiffs, Betty, Stephen, and Robert, witnessed several interactions between John and his kids. They were always happy and joyful. The kids were never afraid. They never saw John abuse his kids. He was always very calm and patient. And Ashley and Lisa pointed out how that continued with John, even when his kids became difficult because of that. The kids were bonded to John, Betty said. John would have tea parties with Ashira. She really looked forward to those on Saturday mornings. He took Zane fishing when he had the opportunity. He even coached Zane's soccer team, according to Stephen. They all talked about how these sex abuse allegations were baseless. There's no way John could have abused his kids. They had known and raised John for 40 years. He was a quiet, introverted, thoughtful, and gentle person. These allegations, according to his father, Robert, just broke him. He didn't even want to talk about it with the family. It was embarrassing to him that he would be accused of such a thing. He didn't want to burden them with these terrible accusations, terrible things. He really didn't want to talk about it much. They wore him down, according to his dad. He felt marked with a stigma. They talked about, this is significant, we're going to come back to this here in a few minutes. You'll see, and you're probably on the side, I guess, that certainly James Brashear committed wrongful death. He's liable for wrongful death for killing John Mast. Well, why is Rebecca liable? We're going to talk more about this. It's a little preview, but that email is crucial to this. She sent that email that same day that John was killed, and that email, according to the Mast family, was very unusual. Very unusual. Rebecca never cooperated with John. Everything was a fight. Everything was a fight with them once the separation started and the divorce started. Everything was a fight. Nothing was amicable. They couldn't talk about anything. They didn't communicate. She didn't want to talk to him. She didn't want to communicate. There was no communication. So that email that day was highly unusual. The timing and nature was very suspicious. And the family now can see that it was a trap and a snare to get John there, and it was part of this Plan B that you heard about. We'll talk a little bit more about it. Focusing on Betty, a couple of things that she talked about and her circumstances. This is important. You heard testimony that Betty was 2 feet away from John when he was killed. She thought she had been shot or was going to be shot because although we focused on Jim walking up to John, saying, "Hi, John," and shooting him once in the chest, he didn't just fire one round. There were several rounds he fired. She thought she'd been hit at first and then realized she hadn't been, but thought she was going to be. Jim looked right at her. Imagine, we can't hardly put ourselves in those shoes. We have to try and imagine what that would be like, the fear, the anxiety that would result from that. And not just in the moment, but for months and years later. Being literally afraid you have been shot or are going to be in that moment, and this could be it. This is how your life ends, right here in a freaking parking lot. She has suffered shock, disbelief, stress, anxiety, fear, and constant pain. She's afraid to open her front door if traffic is going by for fear that a bullet's going to come through. She still lives with that. She testified how if there's traffic, her door faces the street, and if there's traffic going by, when she opens the door, she's careful to open it this way. Still afraid that she might get shot. She experiences panic from time to time if she sees someone with his hand behind his back. She suffered, in addition to all of the mental and emotional distress and damages and injuries, feeling safe as anyone would, and has suffered massive emotional and mental damages, as well as physical. They even sold their property. When this happened, as you heard, they say she and her family were living just north of Coeur d'Alene, Rapid. They sold their property and moved down closer to family because that family needed even more bonding and support at that time. Let's talk about Stephen and his testimony. He was also present in the parking lot when John was shot. He was about 50 feet away. He was in his vehicle. He also thought he was going to be shot because, as he testified, Jim Brashear looked right at him. And that was because Stephen honked, because in that moment, as things were happening so quickly, there was nothing he could do. He tried to do something to stop what he was witnessing happening, and he honked his horn, laid on the horn, trying to distract Jim, trying to do anything he could to save his brother. He honked, and Jim looked his way after having shot John already. Jim looked at Stephen. Stephen thought, it's my time. It's my turn. And he ducked out of the way. He thought he was going to be shot. He thought his life was going to end in that parking lot. He has suffered denial, shock, disbelief, fear for himself and for his sister, and of course his brother. He has later, of course, suffered despair, discouragement, grief, and anger. He's felt disconnected from reality, hopelessness, sorrow, the struggle with forgiveness versus bitterness. This was remarkable to me during the testimony that we heard. Absolutely remarkable that Stephen is considering forgiveness and trying to find it in his heart to forgive, but struggling with feelings of bitterness as we all do. He's suffered short-term memory loss, PTSD, a disconnect from family even though they're extremely tight and bonded. A loss of sleep, a loss of appetite for weeks, anxiety, memory loss. He has seen a physical therapist for back tension for 6 months at $150 a month. He saw a chiropractor for back issues for 18 months at $120 a month. He saw a counselor for 2 years at $200 a month. These are hard costs. This is an unusual case, ladies and gentlemen. Usually in a case involving injury, things like that, personal injury case, I'm beginning to say that we oftentimes have a lot of hard special damages. Those are the hard economic damages, the physical damages that we can actually measure. Hospital bills, doctor bills, things like that. We usually have a lot of those. And oftentimes those are used as a way of calculating the general damages, the pain, suffering, stuff like that. We don't have a lot of hard damages in this case. His family has stoically tried to soldier on through these mental and emotional issues. They have sought help. We don't have a lot of special damages for you to use. It's all general damages. That's not to diminish their suffering, their pain, or the general damages they've suffered, but it's something for you to consider. Let's talk about John's dad, Robert. He said, "We are bonded. Family is everything." He first talked about his faith and how strong their faith is, their family, his faith in Christ and in God. And that's first for them, all of them as a family, but a very close second behind his family and how tight their family is. That's why this loss hurts so much. John, I actually didn't know this. I have not known the family as long as Mr. Hickey has, who helped in the custody battle for 10 years. I came to this much later, and there's things that I'm still learning about the family. I learned this about John during this case, that John was a volunteer fireman. I didn't realize that. He was not capable of abusing his kids. He did everything he could to clear his name. He suffered all the same emotions as Stephen and Betty, shock, anger, and sorrow. He's been through an emotional roller coaster, he said. He's missing John, struggles with this unfairness of having your son ripped away from you suddenly, without any warning. He talked about when Betty called her mom, Sarah, to tell her that Sarah got on the phone and Betty yelled through the phone, "John shot." And they quickly connected John and Sarah, and Robert got on the phone. They tried to connect her parents with their son in that moment to have some final words. That's how they were notified. They immediately then jumped in the car, threw some clothes in a bag and jumped in the car. And Robert talked about driving up here to Lewiston from Emmett and calling out to God to help us. The fact that God did not intervene and save John did not diminish their faith one bit. It's something they still rely on heavily to help them through everything since. Robert testified how they've hung together, they embraced, and they started on a different journey now without John. Sometimes we can see people's scars. Sometimes we can't. That doesn't make them any less people. Let's look at Judge Josh Rustad out of North Dakota. You have an exhibit, 2 exhibits actually, that'll go with you into the jury room. Decisions that Judge Rustad made involving the custody battle between John and Rebecca. This is significant. He presided over the custody battle for several years. He issued first an interim custody order on August 17th of 2018. And in that order, he said, after reviewing the evidence and the testimony provided by cross-examination at hearing, meaning cross-examination, that means in a custody battle, you have these hearings and there's no jury, there's just a judge. The judge is a fact finder, the jury is. And so he gets to ask questions of the parties involved. So judge is saying here, we had a hearing and everybody was subject to examination. In other words, I asked questions myself to figure out what was going on, to get to the bottom of this, as well as having the attorneys ask questions. And after cross-examination at hearing, the court finds that it is in the best interests of these children that John be awarded primary residential responsibility of the party's minor children. What happened a month later trumped up sexual abuse allegations because she was mad that she didn't get primary custody of those kids. She was furious and went to whatever length she could to stop that from happening and started making baseless allegations against John to stop this. And it worked. It backfired on her a little bit because the kids actually ended up going in foster care for 2 months, which is what she wanted. That's what happened because of these baseless allegations. In that interim custody order, the judge also said, and this is important, the evidence presented to the court does not support Rebecca's claims that John physically abused her. She had made a claim that at a restaurant, Basil, in North Dakota, in Williston, that they had gotten into an argument and John had grabbed Rebecca by the arm, yanked her, and dislocated her shoulder. Well, there was video evidence presented at the hearing for this interim order, and the judge got to see the video of that very incident and saw that she was lying through her teeth. The court does not say, the evidence presented to the court does not support Rebecca's claims that John physically abused her. Since Rebecca was not honest about what occurred, the court finds that Rebecca's testimony is not sufficient to find that John perpetrated the other acts of violence and threats of violence alleged. He also said there is not sufficient evidence before the court to conclude that John has abused his children in any way. Let's talk about Ashley Louisa. She owned Dynamic Family Connections in Clarkston, the place where the supervised visits were going on that John was allowed to have for quite a while. And so she supervised most of those visits herself and found that John in those supervised visits was always polite. He was cooperative. He was mellow and soft-spoken. This was, again, remarkable. And she found it remarkable as well. She testified to this, that John, for that time period, when he had these supervised visits that she was supervising, he only got 6 hours of visits, 3 hours on Saturday, 3 hours on Sunday, every other week. That's all he got, 6 hours every other week. And yet, what would he do? He would drive 13 to 15 hours each way from Williston, North Dakota to Lewiston, Idaho, Clarkson, Idaho, to have those visits, to have 6 hours. He would drive 13 to 15 hours, 30 hours of driving every other weekend just to have 6 hours with his kids. It was that important. And he did that for months. He, on his own dime, of course. He wanted more time with his kids. She testified to that. She also testified that Rebecca said no. She took thorough notes of her observations. John was but this is what she observed. These are her observations, by the way. He was a loving father. He was very attentive to the kids' needs and wants, talked about getting them food, doing whatever activity they wanted to do, letting them direct things. He was extremely patient, especially when the kids were alienated from him. He played restaurant and did the Spider-Man puzzle, Marvel puzzle. She talked about that. Why was that important? Because Rebecca had told her the kids are not allowed to do tea parties and they're not allowed to talk about Spider-Man. Those are triggers. Those will trigger the kids. And that we can't have that. And so what did John do? John complied with that. But he still let the kids direct what they wanted to do. So what did Ashara want to do? She wanted to play restaurant. What did Zane want to do? He wanted to do the puzzle with Spider-Man on it. She observed these things, and significantly, she saw the kids were never triggered by those things, even though restaurant was extremely similar to a tea party. And Spider-Man was on the puzzle. No triggers. That speaks to Rebecca's truthfulness or lack thereof. He never canceled visits with his kids. He came every time. He even came once when she no-showed. And it notified Ashley Louisa at 9 a.m. that day that she wasn't going to be there. Actually, she didn't notify her dad. Notified Ashley, yeah, my daughter's not going to be there. Well, John drove from Northville. Don't care. Not our problem. Don't care. She's not going to be there. He was always happy and grateful to be with his kids. And she never saw anything inappropriate from him. He was always respectful. She said he was always very compliant with her rules. He was very obedient. He was respectful to her, to Ashley Louisa, and to the kids. That's what she saw. This came from Ashley Louisa. This is what James Brashear said to Ashley Louisa in the presence of his wife Robin and his daughter Rebecca. All three of them were there. And he said to Ashley, he verbalized this. She didn't make this up. If John ever gets those kids, I'll kill him. I'm serious. Now you heard testimony from Rebecca that she had heard her dad say things like, oh yeah, I'm going to kill him. Oh, I didn't think anything of it. Oh, it's just a fatherly thing to say. Oh yeah, I'm going to kill him. I never believed him. Jim said, if he ever gets those kids, I'll kill him. I'm serious. You think that's something you shouldn't worry about? You think that's just talk? I'm serious. I think Ashley said that Jim's even added, I've been in the Marines. I know how to do this. I'm serious. Let's talk about Detective Crane. Now this, I will admit to you, Detective Crane's testimony goes mostly to Jim's wrongful conduct, wrongful actions. Pretty obvious. You have instructions already that you have to find that Jim Brashear is liable for the wrongful death based on his actions, based on his conviction already. So that's already decided for you. So some of this we really can go through kind of quickly, but there are a couple of things that James Brashear told Detective Crane that are very important here because they relate to Rebecca and what Rebecca knew and how that makes her life. Detective Crane, of course, was the primary investigator after James killed John. James told Officer Lyons in the patrol car that the killing was premeditated. Again, that's not something that cops ever hear. I also practice criminal defense. That's not something I've ever heard my clients say or anything like it, right? Confessing to something so serious right off the bat. He says, yeah, it was premeditated. Detective Crane interviewed and Mirandized James at the station, which is important because he gave James the opportunity to be silent. He told James, you can be silent. You don't have to answer my questions. You have the right to remain silent. You don't have to answer anything. James says, no, I'll talk to you. Sure. He told him that he decided to kill John before he left Rebecca's house. Now, the things that I want you to pay attention to from Detective Crane that pertain to Rebecca, I put in yellow. This is one of them. He decided to kill John before he left Rebecca's house and her apartment, and Rebecca was there. He made the decision to kill John before he left Rebecca's house. They've been together all day that day. You've heard this testimony. They were together all day. They were running all over Lewiston trying to stop this visitation from happening. They were together all day. They were talking. They were frantic. You think they didn't talk about this at her apartment? He made that decision before he left the apartment. You think he didn't say anything to her? He promised Rebecca John would never get the kids. Now, Rebecca denies this. Rebecca took the stand. She denied, I didn't know anything about this. I had nothing to do with it. This isn't on me, right? But Jim tells a different story. Having been Mirandized by the police, sitting there in the police station, doesn't have to answer the questions, but he does. And what does he say? I promised Rebecca John would never get these kids. Said that day. He told Rebecca that day he wanted to kill John. Now, this is important. Detective Crane finds out that Jim has made comments in the past about killing John Mast. And Detective Crane doesn't know what's going on. He's investigating. And he's concerned in the moment that maybe Rebecca did have something to do with this. So he asks Jim specifically, well, when was the last time you talked about wanting to kill John or killing John in front of Becky? He said. And Jim said, that day. He wanted to kill John lots of times in the past, hundreds of times. He told many people prior that he wanted to kill John, including Rebecca. Just heard from Ashley, talked about Ashley and Louisa. He said that very serious comment in front of Rebecca. He switched cars with Rebecca. She saw him do this. He shot John in cold blood at point blank range. We know that. He shot John again as he was fleeing for safety, and he was glad he shot him. Hoped he killed him. Oh yeah, he was the fix-it man. Now, he testified at his criminal trial. His own attorney asked him. It was funny that they brought this up. The prosecution did not bring this up in the criminal trial. His attorney asked him, were you known as the fix-it man in your family? And Jim said, yes, I was the fix-it man. In fact, then he added, you got a problem, I fix it. That's how he was known in the family. Rebecca did this. Detective Crane, I asked him, what was James' demeanor during the interview? And actually, I did really need to ask him this. I had to testify about it. You got to see the video. You guys see the clips. You can ask yourself, what was James' demeanor in there? But Detective Crane testified he was very matter of fact and calculated. I mean, he just seemed indifferent, having just murdered someone. Detective Hendricks, she's a sergeant detective with the Wilson, North Dakota Police Department. She was the primary detective on all of the allegations of abuse against John Mast. She investigated these for a year and a half. She has extensive experience in child sex abuse cases. And we asked her specifically, when you've got these allegations from the brochures, because you can tell they involved a custody battle, did that make you take them any less seriously? She said, absolutely not. I am a huge child advocate. It's all about protecting kids to me. I took these allegations extremely seriously. Her investigation was thorough. It took over a year and a half. She requested a forensic interview of the kids in Idaho. She interviewed John. She had a second forensic interview done in North Dakota. He passed a polygraph. I neglected to put this in here that Mr. Hickey drew out of Detective Hendricks on the stand that John also completed what's known as a psychosexual evaluation. That's given to people to determine their propensity to commit sex crimes. John came back with zero propensity. That was another part of her investigation. She then, fearing that she was missing something, feeling frustrated that this avalanche of allegations was coming at her from the brochures, just constantly new allegations. She's thinking, I've got to be missing something. What am I missing here? I got to protect these kids. I'm not seeing anything. What am I missing? So she ran the case file, the entire case file, past several of her law enforcement colleagues. She ultimately ran the case file, took it, the whole thing to the prosecutor in her county. had them take a look at it. She said, I wanted a lawyer's eyes on this. Tell me if I'm missing something. She wasn't. No one saw any evidence whatsoever. It was an avalanche of aggressive allegations. But John made himself 100% available to all parts of that investigation. He stayed in close communication with Detective Hendricks, and there were no concerns on that psychosexual evaluation. Detective Hendricks testified that she had serious concerns with Rebecca's truthfulness. Are we starting to see a pattern? Serious concerns with Rebecca's truthfulness. It was very apparent that the kids were pawns, simply pawns in a custody battle. And that made her and makes her today to be very concerned about the kids and that they're not in a safe environment, even today. She then met with the Brashears at the end of her investigation to explain the results to them. I mean, she kind of went out of her way. She doesn't have to do this. Law enforcement, I'll tell you again, from a criminal defense perspective, I get a lot of people calling me up saying, hey, I'm being investigated. What do I do? And I said, you got to wait and see what happens. Play out. And then oftentimes they never hear anything. The investigation happens and they're never contacted again to say, oh yeah, you're clear. They never get that. In this case, though, Detective Hendricks went out of her way to explain the results to the Brashears personally. She wanted to break the news, right? But she was also kind of happy to have them come in because she was happy to share the news with the Brashear family that she had found nothing. In other words, the kids are safe. The kids are fine. She was excited to share this news with them. She thought she would get the same kind of response, this relief, like, oh, thank heavens, the kids are okay. Is that what she got? The response from the Brashear family. When I say Brashear family, I mean Rebecca, James, and Rob. They were there, all three of them, with Detective Hendricks. The response was anger towards Detective Hendricks, not relief. They were hostile to her. You've seen this cane that this convicted felon has been carrying around this whole time. He had that cane with him and he slammed her table. Imagine slamming the table of law enforcement, of an officer wearing a badge and a gun. He slams her table because he had no respect for her at all. He slammed her table with his cane as if to threaten her. But then he doubled down. He made a verbal threat against John in Rebecca's presence and in law enforcement presence. Detective Hendricks had to tell him, no. I'm an officer. I'm law enforcement. You don't get to say things like that. You don't get to threaten people in my presence. You go to jail for that. Detective Hendricks talked about she had no probable cause to make an arrest of John. Probable cause, similar to our burden of proof today, means 51%. She needed to be persuaded 51% that these allegations were true. She was not. She said, I did not have 50%. Mr. Hickey asked her, did you have 10%? No, I had 0%. 0% evidence that John did anything wrong. This is from Detective Hendricks' letter that she sent the Mast family after she learned that John Mast had been murdered. And you have that letter. You'll have the letter in the jury room with you. From that letter, she says, she told the Mast family, anytime there's a report of suspected child abuse or neglect, it is the utmost priority to ensure the safety of the kids. I know firsthand, as I worked the cases with John, these allegations, there was no sufficient evidence to establish that your son had done anything wrong or committed any crimes. When she heard that John had been murdered, her heart went out to the Mast family. She wanted them to know. See, she didn't meet with the Mast family to tell them the results. She met with the Brashears. They didn't know all of this. She wanted them to know that John died an innocent man. John was beyond cooperative with all of the criminal investigations and even went so far as consenting to do a polygraph, which he passed. My criminal cases with John were closed years ago, no charges filed. Let's talk about Rebecca. She was frantic to stop the visitation. Her words. Her dad told her that he was going to follow John. Again, her admission. She knew her dad always carried a gun. She had heard her dad say many times that he wanted to kill John. She heard this Plan B phone call. Mr. Hickey talked to her about this and attempted to talk to Robin Brashear about it, who denied having this phone call. She suddenly had selective memory issues. But he did talk to Rebecca. Rebecca admitted that on the way from the courthouse to her apartment, she and her dad were in the car, and her dad called her mom, Robin, and she could hear the conversation, at least one half of it. And in that conversation, James Brashear said to his wife, Robin, something to the effect of, well, it looks like Plan A, or Plan A meaning to stop the unsupervised visitation through legal means, and said, I guess we'll have to go to Plan B. That's the Plan B. Plan B involved following John. She knew that her dad had moved his gun from the white vehicle, kept hearing about the white vehicle as a Kia, to the Suburban that she regularly and normally drove, according to many witnesses that we heard throughout the trial. She knew her dad took that Suburban. She knew her dad left about 10 minutes before she did. She then, after her dad left, probably about 5:40, we think, left her apartment, she sends an email to John at 5:45, the day of the killing, and says, I will have the kids there at 6 p.m. Again, that was an unusual email for her to send. She had never sent emails. She had never been cooperative in these custody exchanges. And she sent this email to make sure John would be there. I'll be there at 6 p.m. She then, this is something that I picked up on, she then admitted here in trial that she arrived at about 6:02 p.m. And we do know she was there shortly after the murder happened. The police were there. So she admitted on the stand that she arrived at 6:02. Now, why is that? To me, it's important because we also heard testimony from Detective Crane that he drove the route from her apartment to Rosar's, and it took 2 minutes, 45 seconds, less than 3 minutes. Instead, she arrived at 6:02. If it only took 3 minutes to get there, she didn't leave in time to be there at 6 p.m. like she promised John she would in her email. I will have the kids there at 6. She intentionally left at a time when she would be late. She wants to make a big deal about, well, I was within the 15-minute grace period. That's not what we're talking about. And you'll probably hear from her say that. I was within the 15-minute grace period. It's okay for custody exchanges. I'm within 15 minutes. That's not the point. The point is she had John there at 6 o'clock on purpose, and she arrived late on purpose to give her dad a chance to carry out Plan B. She had no intent to comply with that email. Rebecca has zero credibility here. She lied to Judge Rustad in North Dakota about the restaurant incident we talked about. She lied to Ashlyn Weza about the kids' triggers. Detective Hendricks was concerned about her truthfulness. Rebecca testified in a deposition that I took with her in civil cases. We take a deposition ahead of time. I took her deposition. It was under oath. We had a court reporter present. And this is what she said. Then she told Detective Crane that as her dad was leaving to go to Rosar's, they were both outside the apartment together, and her dad was getting ready to leave. So she watched him take her vehicle, move his gun. She watched all that. And then she told Detective Crane, and you heard this, you heard her own words, and we had hoped to play a video clip. You only got the audio for it, from it. But her dad told her, or she testified that her dad hugged her, said goodbye, which was kind of interesting, and then told her, you don't have to worry about anything. She heard that. And again, these are Rebecca's words. Detective Crane asked her specifically in her interview that night of the killing at the police station, and she was free to leave. She wasn't under arrest. She wasn't in custody. She was free to answer or not answer. And he asked her specifically, well, did you think in any way that your dad was going to do this tonight? And she slipped up. She knew that what he was going to do. She slipped up because at first she said, oh, no, no, no. Well, I thought it was possible. And then she slipped up again and admitted that she had thought seriously about killing John. She'll tell you, has told you, oh, no, no, I've never thought about killing John. I've never threatened to kill John. I've never thought about that. Oh, I would never want that to happen. I would have called the police if I known. But she told Detective Crane that the day of the killing, before the killing, when she was frantic to stop the unsupervised visitation, when she's running around Lewiston trying to stop it, they're at the courthouse trying to get a protective order. The judge says, no, not going to grant it today. She's extremely frustrated. She and her dad are at the courthouse. They're talking to a sheriff's deputy. They're waiting for the judge to come back. And she admitted to Detective Crane when he said, have you thought about this? She said, well, I was about there. I was about there. In fact, it was in response to and this was in the audio that you heard from her, that a sheriff's deputy there at the courthouse, when they were talking about this, the sheriff's deputy actually, strangely enough, said, well, you know, there's ways of handling this. And I don't know if he was trying to be funny or stupid, or I don't know what, but there's ways of doing this. And she said, I'm about there. James Brashear told Officer Lyons in the patrol car the killing was premeditated. He thought about killing John. He weighed the cost. He got to the parking lot first. He lied in wait. John was arranging the car seat. As Jim approached him, he shot John once in the chest, and then 3 more times as he was running away. He told Detective Tyler Crane he'd wanted to kill John for a long time. He'd thought about doing it hundreds of times. He'd said this out loud in front of others. He said he just wanted to kill the dirty bugger. He had previously told Rebecca he wanted to kill John. Told Rebecca that day he wanted to kill John. Promised her that day he'll never get the kids. Made a conscious decision at the house to kill John. Told Detective Crane that he switched cars, moved his gun, always carried a gun. Rebecca knew that. Drove to Rose hours before Rebecca, laid in wait, approached him like a friend to throw him off, hid the gun, shot him in the chest, chased him. After the murder, he texted his wife, it's done. What's done? Plan B is done. Plan B from the Plan B phone call that he had with his wife just minutes before he went to Rose Ours and killed John. I guess we'll have to go to Plan B. Plan A didn't work. We'll have to go to Plan B. Why else would he text his wife Robin at the end? I mean, if you get a text like that, she'd be thinking, what's done? But what does this mean? What are you talking about? It's done. They'd already talked about this, Plan B. And significantly, in Rebecca's presence, because that call occurred in the car when James and Rebecca were together. When James murdered John, John was not fighting with anyone, abusing anyone, not threatening anyone, not even raising his voice. He was unarmed. He was making his car safe for his kids. James ambushed John like a craven coward, not like a former Marine. I say that coming from a family where my younger brother, Steve, served in the Army, attained the rank of captain. And my brother Jeremy serves in the Air Force, has attained the rank of colonel, still in lieutenant colonel. I know what that means. Have a military background. James fired his gun multiple times. This is significant. We didn't hear much about it. We had anticipated testimony from James about how safe he is with guns, and he's a gun safety advocate, or at least we hear this from Rebecca. He's a gun safety advocate, so forth. We didn't actually hear that, but I made a note here that he fired his gun multiple times in a crowded public parking lot during prime shopping hours with zero regard for public safety. I don't know how much that matters. Just thought that was interesting. James has zero credibility. He testified at his criminal trial in August of 23 that he had no idea that unsupervised visitation was going to happen that day, February 5th. But he sent Rebecca a text on February 4th regarding the time of the visitation the next day. So he knew the visitation was going to happen. He knew it was going to happen at 6 p.m. And that text message, you'll have that in the jury review back as well. I think I passed it around. It said that John, he acknowledged in that text to Rebecca that John will pick up the kids. He wasn't talking about, they want to have you believe that what this meant was, oh, we thought it was going to be supervised, even though they knew the judge had ordered unsupervised 2 months earlier. And Jim said he knew that John would pick up the kids. If it's supervised, John's not picking up the kids. He's going to go visit them at dynamic conventions. If he's going to pick them up, it's because it's unsupervised. And he knew that. In other words, he lied on the stand at his criminal trial. He testified at his criminal trial that the murder was not premeditated. He told Officer Lyons immediately after that the murder was premeditated. He testified at trial that he did not consider killing John before he did it, yet he told Detective Crane that he decided to kill John while still at Rebecca's apartment, and he weighed out the cost. He testified at trial that he put the gun in the suburban console for safety, because it's such a huge gun safety advocate, and yet he told Detective Crane that he left the gun on the passenger seat. Put it on the passenger seat when he left. It was still there when he got to Rosar's. Testified at trial, he did not think of killing John that day. Told Detective Crane he had thought of killing John hundreds of times. Told Detective Crane that he said in times past, I'll kill the dirty bugger. Told Detective Crane that people had heard him talk of killing John. Told Detective Crane he told Rebecca that day he wanted to kill John. James Brashear is a liar. He lied in his opening statement. This is significant. Kevin pointed this out to me, that James Brashear stood up at this podium the first day and gave an opening statement. Now, the purpose of opening statements is to tell you, like I said today, tell you what we're going to tell you. It's to tell you what the evidence is going to be. In other words, we're going to show you X, Y, Z. James got up and said a lot of stuff, and said a lot of things that you would hear, and promised you that he would provide evidence that Rebecca had nothing to do with John Mast killing, and then provided no such evidence, even when he had the chance. He wouldn't answer any of my questions, but he also didn't answer hardly any of Rebecca's. And there was no testimony when Rebecca got up to question him, and of course you all know this, that he wouldn't answer any of my questions, but he would answer hers. But there was no testimony at that time that she was not involved. He had the opportunity. He could have said, she could have asked him, was I involved in this? Did I know anything? She didn't. He didn't say it. He said he would give you evidence that she was not involved, and he didn't. He also didn't call any witnesses, by the way. I'm sure you noticed that. coldness and the evil of these two people. It's staggering. I told him, finally, there's something we can agree on. Defendant's evidence, I left the slide blank because they didn't really provide any. Let's look at wrongful death, the elements. These are in your instructions, so I won't dwell on this too much. But the two elements that have to be proven in a wrongful death suit are that an actionable wrong was committed by the defendant against the decedent, and that the same actionable wrong caused the decedent's death. Well, that's obvious. James Brashear has already been decided for you in his criminal action. So that's not something you have to worry about with James. Nevertheless, we can listen to James. Or maybe we can't. Now, sorry. I don't think I set this up right, but I played the clips for you. And you saw them yesterday, so. Now, this is where we got to talk about this a little bit. The wrongful death committed by James Brashear is obvious. Like I said, it's been decided already. The wrongful death by Rebecca Brashear. Now, this one's a little bit more complicated. I think I've explained it pretty well so far, but I want to talk to you about this. And I want you, if you would, turn with me in your jury instructions. Gotta find it. Okay, if you would look at instruction number 9. Number 9 says that evidence can be either direct or circumstantial. Direct evidence is evidence that directly proves the fact. We have that on James Brashear. Circumstantial evidence is evidence that indirectly proves the fact by proving one or more facts from which the fact at issue can be inferred. Now, this is the important part, okay? Because our case against Rebecca is circumstantial. But look at what the instruction says. The law makes no distinction between direct and circumstantial evidence as to the degree of proof required. Each is accepted as a reasonable method of proof and is respected for such convincing fortune of the hearer. So you have heard, or you'll hear in movies and TV shows, you'll hear the actors, the characters in the show talk about, well, it's just circumstantial. It's only circumstantial. That's it, that makes it less strong. That's not true. That's Hollywood. Circumstantial evidence carries the same amount of weight, whatever weight you assign to it, as direct evidence does. The case against Rebecca is circumstantial. We don't have direct evidence that she killed John Mast. We have circumstantial evidence that she participated in having it. So let's look at that. An actionable wrong, in order for her to be liable, she had to commit an actionable wrong against the decedent. And that's the email that she sent in. You'll have a copy of this. You saw this during trial, and you'll have a copy of this in the jury room. You go back and look at it. But that's her email to John saying, I will be there with the kids at 6 p.m. That was the actionable wrong. Okay, we're going to talk about how that contributed to his death. Why was her email the actionable wrong? She knew her dad was furious that day. She knew her dad had talked many times about wanting to kill John. Her dad told her that day he wanted to kill John. Her dad promised her that John would never get the kid. Her dad was the fix-it man. She knew her dad always carried a gun. She had never communicated with John ahead of time about custody exchanges in the past. She knew her dad was going to follow John. She didn't care what her dad did. She knew her dad took the Suburban. She knew her dad left before her to go to Rosar's. I don't mean to, again, I certainly don't want to talk down to any of you, so I hope I'm not banging over the head too much with all this, but you know, the point with the Suburban, right? is our point that we're trying to make, and I'm sure you've already figured this out, is that that was part of the deception. He took the Suburban because everybody knew Rebecca always drove the Suburban. So he took the Suburban on purpose so that John would think Rebecca was there. Yeah, that's right. Significantly, Rebecca did not warn John. She didn't even stay silent. She could have taken any one of those avenues. She could have left it alone, in which case we probably wouldn't have a case against her. If she had just left it alone, not said anything, then she would have plausible deniability that she was involved anyway. I had nothing to do with this, but she sent the email and intentionally left her apartment knowing she would be late and not in compliance with the email. The email she sent 15 minutes early. She knew she wasn't going to comply with it. She didn't warn him. She didn't stay silent. She took an affirmative step. At best, for her, that email, given all that she knew, everything I pointed out and other things that you've heard during the trial, constituted a failure to warn John of the danger that she was aware of, or should have known, that her dad posed, which failure was an act of gross negligence, which is part of the instructions. At best, for her, it was gross negligence to fail the rule. At worst, that email, given all that she knew, constituted an intentional act of wanton and willful cruelty designed to set John up and deliberately expose him to the danger that she knew her dad. Either way, she's liable for wrongful death. Either way, she's liable for punitive damage. Either way, she's on the hook for intentional infliction of emotional distress. Doesn't matter. Either way. Either way, her act was an actionable wrong that contributed to John's death. This is from Idaho statute 5311. That is the statute that governs wrongful death. And it says that when the death of a person is caused by the wrongful act or neglect, okay, just talked to you about her actionable wrong, could be considered an intentional act of cruelty, or it could be considered gross negligence. Either way, it fits within wrongful death. The wrongful act or neglect of another, his or her heirs or personal representatives on their behalf may maintain an action for damages. Now, the heir in this case, as you know, as we testified, had her testimony, is Robert Mast, the father. He's the heir. He's the one that's entitled to an award of wrongful death against Jim and Rebecca. And in every action under this section, such damages may be given as under all the circumstances of the cases may be just. You have further instructions in here that the judge went over, and you can read them again about how to calculate damages, what's covered. But I want to draw your attention to, I think it's 22 and 23. Yeah, I'm going to do 22 and 23 both. Yeah. Just want to point out to you, in instruction number 22, this is talking about negligent. It actually says negligent, but this is talking about intention. No, it's just talking about negligence. Anyway, the point I wanted to make is in that first paragraph, at the last sentence of that first paragraph, you see, or the sentence above that, the jury must determine the amount of money that will reasonably and fairly compensate the plaintiffs for any damages proved to be caused by the defendant's negligence. Any damages. I want you to keep that in mind as you're deliberating. Well, what can we consider? How much can we consider? Any damages. General damages, specific damages, punitive damages, damages for using a gun. All of those are at play. Wrongful death. Any damages are at play here. And if we look at 23, you'll see the same thing. So the 22 is the instruction on damages in general in injury cases. 23 is the specific instruction on damages in wrongful death. And look again at that first paragraph, third line, any damages. The jury must determine the amount of money reasonably and fairly compensate the plaintiffs for any damages proved to be proximately caused by the negligence. Look down below in that same instruction at paragraph, it's number 3. I want to kind of help you out here a little bit. In 22 and 23, you'll see a lot of things. These are general damage instructions that are given in most cases, pattern jury instructions. And they cover a lot of stuff that really isn't a plaintiff, that really cover loss of services, loss of ongoing support, things like that. We haven't provided any evidence of that. We don't understand that. Our case is mostly about what you see in actually back on 22. We could go back a page, I'm sorry. If you look at 22 and you see subparagraph A, non-economic damages, and you look at 1 and 2, you can consider damages for the nature of the injuries and the physical and mental pain and suffering past and future. That's mostly what we're focused on here. The rest of it, you probably don't need to spend a lot of time on it. Read about because we have fun about that. If you look at 23, similarly, we have not put on any evidence about the cost of the deceased's funeral. There was no medical care or expenses, at least for John. Stephen did have some medical care. Banks had some medical care. We didn't give you a number on that. Mostly what we're focused on here is in paragraph 3, the reasonable value for the plaintiffs of the loss of John Mast, the loss of his comfort, or in other words, love, the loss of society with him, in other words, the whole of their family now. And then take into consideration, it says the life expectancy of the plaintiff and the decedent's age and normal life expectancy. Her testimony that John was only 40 years old when he was killed. So the family could have expected to have him around another 40 years. I want to point something out to you so that there's no confusion. If you go to the bottom of 23, you see down there it says death is inevitable. It says, although the law compensates for the untimeliness of the death caused by another, no damages are allowed for grief or sorrow. We've talked a lot about grief or sorrow. That might be a little confusing to you, okay? Look below that. There can be no recovery for any pain or suffering of the decedent. Right. Idaho law says that we can't sue for John's pain and suffering. That claim dies with him. That's Idaho law, okay? But when we talk about the plaintiff's pain and suffering, and it says here you can't award damages for grief or sorrow. You can't award damages for grief or sorrow, but you can award for pain and suffering. And if they had meant that, they would have used that phrase. They used the phrase, when people wrote this instruction, used the phrase pain or suffering, pain and suffering in the bottom line. They didn't use it in the line above. That means that pain and suffering is in play. You can remove that. Very quickly buzz through this because you have it in your instructions, but under intentional infliction of emotional distress, in order to establish that you have the elements there that you have to, we have to prove to you that the defendant's conduct was intentional or reckless. Now, I'm pointing this out because we know Jim's conduct was intentional. Question. Our argument is that we think Rebecca's email was also intentional, but even if you find that it wasn't necessarily intentional, it was at least reckless. Now, we are not claiming that Rebecca Brashear is some kind of criminal mastermind and plotted this together, and there was some vast conspiracy here that lots of questions on it. I'm kidding now. She's not a criminal master. She's not a mastermind of anything. But what I think happened is she took advantage of the situation. She took advantage to continue to try to maintain control of the custody of those kids. She saw something happening. She was smart enough and conniving enough to see the wheels turning and just jumped on board. She took advantage of her dad in a blind rage, carrying a gun, and thought, I can just kind of nudge this along. Email to John to make sure he's there. At best, it was reckless. And the conduct of both of them was extreme and outrageous simply because it resulted in John's death. And that was the intent, to take John out, eliminate this so-called threat, and be done with it. Their conduct was extreme and outrageous, and there was a causal connection between what they did and the plaintiff's emotional distress. And of course, their emotional distress over the loss of their son and brother is, of course, severe. Just to point this out to you, there is a distinction between intentional infliction of emotional distress and negligent infliction of emotional distress. Intentional infliction does not carry a requirement that there be a physical manifestation of injury. Negligent does have that requirement. So we talk about that. Oh, this is showing you how Stephen Mast and Betty Troyer have suffered intentional infliction of emotional distress. We talked about, so these are the same elements, you know, the conduct was intentional or reckless. Well, Jim killed John in front of them. Rebecca intentionally or recklessly sent an email. James intentionally killed John in cold blood. Rebecca sent the email or failed to warn him, knowing all she knew. There was a causal connection because the murder of John in front of them caused their distress, and Rebecca's email lured John to his death. They both testified to the severe emotional distress they've suffered from the day of the murder until now. Negligent infliction of emotional distress. The elements are a legal duty recognized by law, a breach of that duty, causal connection between the breach and the injuries, and then actual damages. And there has to be a physical manifestation. So let's look at that real quick. Look at the elements of legal duty. James had a duty to not kill anybody. How more basic do we get? Rebecca had a duty to act with reasonable care towards John, and all she had to do was not send the email. All she had to do was stay silent. There was no duty imposed on her by law to warn John. She actually didn't have a duty. But once she took the affirmative act of sending the email, she then assumed the risk. She sent the email to him and assumed the risk that if something happened, that's on her. She had a legal duty, and she breached it. Stephen and Betty both testified to their losses and damages, and they both had physical manifestations of their injuries. We heard testimony about that as I talked to you about that today. We're getting close to the end, ladies and gentlemen, just to give you a preview. Civil liability for death by firearm. Idaho allows this. We have a special law in Idaho that if someone is killed or injured by a firearm, you can award damages specifically for that, just that, on top of wrongful death, on top of emotional distress. You can award on top of punitive. You can award damages just for this. Now, this would apply only to Jim. He's the only one that used a gun here. But that's the law. And to establish that, you have to find that he killed him with a gun. Pretty obvious. And if you find he did, then you have to determine the amount of damages, if any, that should be awarded based on the evidence presented at trial. So that'll be up to you. Punitive damages. Let's look at this. If you find, this is the law on punitives that comes out of Idaho statute as well. If you find the defendant's acts which proximately caused the injury, the shooting and the email, you find those acts that proximately caused the injury to the plaintiffs, if you find that they were an extreme deviation from reasonable standards of conduct, and that these acts were performed with malice, fraud, oppression, wantonness, or gross negligence, you may, in addition to any other compensatory damages to which you find the plaintiffs entitled, you can award the plaintiffs an additional amount for a specific purpose, to punish the defendant and deter them and others from engaging in similar conduct in the future. That is straight out of Idaho statute, straight out of the law. The point of punitives is to punish wrongful conduct. Make sure it doesn't happen again. We have malice with James. We certainly had malice and forethought when he decided to kill John and drove to Rosars and did it. With Rebecca, we have at least gross negligence. I would argue there was malice in sending that email and putting John in danger intentionally, but if not, if you disagree with me, there was at least gross negligence in doing that because she didn't have to do it, and she never had before. Rebecca did not warn or stay silent. She took an affirmative step to lure John. James murdered in cold blood. This was an extreme deviation from reasonable standards of conduct. How is this an extreme deviation from reasonable standards of conduct? I'll tell you. What are the applicable reasonable standards? Thou shalt not bear false witness. Where have we heard that? That's a reasonable standard of conduct in our society. Don't lie. Don't send an email to somebody saying you're going to be there when you know you're not going to be there. Doing it to put him in danger intentionally, knowing your dad would be there with a gun and his fury. Thou shalt not kill. Those are pretty reasonable standards of conduct in society that were violated here. These acts were performed with malice, fraud, oppression, wantonness, or gross negligence. All right, what's it worth, ladies and gentlemen? Compensatory damages, what are they? What are they for? Who deserves them? What's the burden of proof? How do you calculate the burden of proof? In all of the compensatory damages except punitive damages is 51%. That's all we have to prove to you. If you feel like we've proven to the level of 51% that the Mast family deserves compensatory damages, that's the burden. So how are you going to calculate it? Well, that's really up to you. In wrongful death, it's the amount of money that will reasonably and fairly compensate the plaintiffs for any damages proved to be proximately caused by the defendants. Who deserves the damages for wrongful death? That's the heir, and in this case, Robert Mast. How do you calculate them? In every action under this section, such damages may be given as under all the circumstances of the case as may be just. Whatever you think is just to compensate Robert for his physical, mental, and emotional losses and pain and suffering. Let's look at the emotional distress claims. What are they for? Emotional distress, of course. Looks like I did not do this as well as I thought. Emotional distress and medical expenses can be considered lost income due to mental and emotional suffering, loss of enjoyment of life, reduced quality of personal relationships, pain and suffering, mental anguish. Those are the things that we're really concerned about here today, the things that I put in red. Loss of enjoyment of life, loss of companionship, loss of relationships, pain and suffering, loss of society, love and comfort. Who deserves the emotional distress claim damages? It's Stephen and Betty. Anyone who suffered these kind of damages as a proximate result of the intentional or reckless, extreme and outrageous conduct. Betty was in the line of fire. Stephen watched his brother's murder. Robert has lost his son forever. So how are you going to calculate these damages? There's no set formula. You get to decide what Betty's and Stephen's and Robert's losses and emotional pain and suffering are worth, and the loss of their son or brother. You get to decide what message to send. Trying to hurry through this, ladies and gentlemen. I know we've been at this for a while. Punitive damages, what are they for? As I just said, the point of them is to punish, deter, send a message. So who deserves them? What's the burden? Okay, this is where we talk about different burden. Clear and convincing. I mentioned this earlier at the beginning. You have beyond reasonable doubt, doesn't apply here. You have preponderance of the evidence, which applies to false claims. And then you have clear and convincing, which applies to the punitive damages. So it's a higher burden. You have to decide whether or not we provided clear and convincing evidence on the issue of punitive damages. So what is clear and convincing? Like I said, it's between those. It's more than preponderance, which is 51%. It's less than beyond a reasonable doubt, 95%. So it's probably around 75%. If you're 75% convinced that we've proven punitive damages, then you can award them in this case, and should. How are you going to calculate them? The instruction says that they are in addition to any compensatory damages. Sorry, I screwed up this slide. And you can calculate them in an amount which will punish the defendants and an amount that will deter others from similar behavior. You get to decide what amount that'll be. You get to decide what amount that will be, but we talked about it in voir dire, and one of our jurors asked us specifically, well, how much, would be appropriate in a case like this if you're sitting on the jury? We talked about that. And I kind of threw the question back to all of you. How much is it? I don't want to tell you. I want to leave that up to you. But remember that most of you felt like it would not be inappropriate to award in the millions if necessary to send the right message. Don't be afraid of that if that's what you feel. And leave that up to you. You don't want to dictate that to you. That's the province of the jury. But don't be afraid of that. I made a slide here about verdict forms. I'm not going to go through that. The judge went through that. You've got that with you. I just want to go to some final thoughts real quick. Edmund Burke. Edmund Burke was the man who said this. He was a British politician and philosopher who lived 1729, 1797. He lived and was in British Parliament during the Revolutionary War. He was significant in Britain's history. He was the one that said this quote that we've heard many times. The only thing necessary for the triumph of evil is for good men and women to be done. John just wanted time with his kids. That's all he wanted. He just wanted to enjoy time with his kids. The Brashears were desperate to prevent it. They engaged in dark and evil deception and intentionally caused it. Dark and evil deception enough to accuse this good and innocent man of sexually abusing his kids. It doesn't get much darker and evil than that until you get to February 5th, 2021, and then it does. John will never get time with his kids or his family again. Thanks to them. Jurors, you get to think about all of this stuff. Think about it, just like James thought about it, weighed out the cost. You now get to think about it, weigh out the cost. You get to weigh out the cost of this to the defendants. I just ask you, don't let evil triumph. Don't let these two evil people who committed evil acts of atrocity, don't let them triumph. Punish their wickedness. Send a clear message to them, to this community that you all live in. Send a clear message. That you consider the evidence in this case. Thank you.
Thank you. All right, ladies and gentlemen, I'm looking at the clock. Let's take our morning recess. Let's take 15 minutes and we'll reconvene at 11 o'clock. I'm going to read you this. I believe this is going to be the last time. Members of the jury, I remind you that you're not to discuss the case among yourselves or with anyone else, nor to form any opinion as to the merits of the case until after I finally submit the case to you. With that, please rise for the jury. Anything that we need to take up before we return the jury?
No, Your Honor.
Okay, please rise for the jury. Okay, please be seated. Thank you very much. Record will reflect that the jurors have returned. They appear to be properly seated to me. Will the parties stipulate that the jurors have been returned and are appropriately seated?
Yes, Rob.
Yes, Your Honor.
Very good. All right. Mr. Brashear, you may present any closing argument.
Thank you all for coming, serving, and spending your time and being patient. We all appreciate that very much. I don't have a whole lot to say. I've never been to a hearing like this, or done this. I've always heard that if an attorney, if you can't afford an attorney, one will be appointed to you. But that's not the case on a civil case. So what you're seeing here is two, and I compliment them, they're professional attorneys. They know what they're doing. And my daughter and I are forced to represent ourselves. It's kind of a David versus Goliath type of thing. I don't have a lot of fancy videos. I noticed that he put one up about a hot dog and ketchup and won some of you over to his side. That was pretty creative, I thought. You even had you giggling and laughing and joining in with him right off the get-go. But as the trial continued, I wondered, why am I being retried? It was like a retrial for me. And then I realized it was to include her. My daughter had nothing to do with that. Like I said, I have no videos, I have no computers. I don't even know how to turn one on practically. The only proof that they have against my daughter is that she emailed John, to connect it with the thing. If she emailed John at 6 o'clock at whatever time and said she was bringing the children. How many people have done that? And they keep saying she's never done that before. Well, there's no proof of that. So all I have to ask, all of you have common sense. So I'm asking you, when you go in there to deliberate, please use some common sense. Ask yourself a question. For example, if we had a big mastermind plan, like he said, to kill John Mast, do you think that we would do it at Rosar's parking lot? I lived up in Winchester. We hunted, fished, and camped everywhere. We knew every cliff, Rosar would not be a good place to do it. There was no plan. I believe, even now, with all my heart, that our children, my grandchildren, were being molested by John Mast. I'll always believe it. When you go in there and deliberate, I ask for one other thing. Ask yourself, if you knew in your heart, if you believe with everything in you, that letting those children who were begging and pleading and crying and saying, Grandpa, don't make me go with them. what steps would you take after 3 years of going, or however long, going back and forth, and not, and you end up with all of it. I couldn't do it, but she had nothing to do with it. They put me on a retrial today so they could connect her. She's not connected. My wife's not connected. It didn't happen that way. Something flipped in me and I went and shot him. Another thing is the fact that I was so calm and all that. Use your common sense. I was cuckoo. Anybody else would have been. He's right. I was trained. I was never in the Marine Corps, by the way. But I was in the military. And in that, you're trained to give your name, rank, and serial number. Use your common sense. Why didn't I do that? Because I'd lost it. I had a brain bleed right before, or a few years before that, and it really caused me short time and long time memory loss. It's getting worse. It's really bad. I don't remember like going to school all the way up to 8th grade like Stephen did.
Your Honor, I hate to interrupt closing arguments. He's talking about stuff that's not in evidence. He's been talking about a lot of stuff that was not introduced in evidence. This is about what was introduced in trial.
I will sustain that objection. Mr. Brescher, I'm going to ask you to argue based on the evidence that was submitted.
That's all I have to say.
Thank you.
Thank you.
All right, Ms. Brescher, Mast, you may present any closing or summation that you'd like.
Yes, Your Honor. The judge and jury, first, I want to thank you all for being here. I know this hasn't been easy. You've taken time from your lives to listen to a painful and complicated story. I'm deeply grateful for your attention and for your willingness to listen. Especially when I'm standing here without a lawyer, just a mother trying to defend herself. These past few days, you've heard a lot. You've heard skilled attorneys paint a picture of me as someone who somehow orchestrated the death of my children's father, as if I had knowledge of or involvement in a plan to kill him. That is not only false, it is cruel. Let me be clear, I had no idea what my father, James Brashear Sr., was going to do on February 5th, 2021. He acted on his own in a moment of emotion and rage that I neither knew about nor supported. I was 2 minutes late for the custody exchange. That is the only thing the plaintiffs are pointing to, 2 minutes. That is their entire case. They have no text messages where I hinted anything, no emails, no phone calls, no plan, no conspiracy. Just a mother saying she would be there in 20 minutes and showing up 2 minutes late. That's not evidence, that's life. We all run late sometimes, and in a case this serious, where they're accusing me of being part of a killing, you should demand actual proof, not guesses or assumptions. There have been many times in my life when people misunderstood my actions or judged me harshly, especially when I was trying to protect myself and my children. I've been called names, criticized for speaking up, and even more often for staying silent. But I acted the best I could with the tools I had at the time in an effort to keep my kids safe and survive a very painful situation. That doesn't make me a criminal. It makes me a mother doing her best under impossible circumstances. I've survived a childhood of abuse. I've survived a marriage that included emotional, physical, and sexual abuse.
Your Honor, I hate to object. There's been no evidence of any of that. She cannot refer to that at closing.
I'm going to sustain that objection. Mr. Brescher, Mast, again, I'm going to ask you to refer to the evidence that's been admitted at trial, and I will give you leeway in terms of making arguments surrounding that, but I do
Yes,
need you to
Your Honor.
refer just to the evidence that was admitted.
I've survived the family court system, which did not believe my concerns about my children's safety. And now I'm standing here still trying to survive, this time a lawsuit built on grief and assumption, not facts. I do not condone or support in any way my father's actions on February 5th, 2021. I have said that from the very day it happened, and I say it again now. What he did was wrong. And I would give anything for that day to have gone differently. But I am not on trial for his actions. He acted alone. He was convicted. He is serving his sentence. I had no part in what he did. My children have already lost their father. As you can see, they lost their father. They should not have to have their financial stability jeopardized simply because others are looking for someone to blame. I stand here today and say again, I did not know what my father was going to do. I did not plan it. I did not encourage it. And I would give anything for it to not have happened. I am not a monster. I am not a criminal. I am a mother. I am a survivor. Please find me not liable in this lawsuit. Thank you.
Thank you, Ms. Brashear Mast. Mr. Hickey or Mr. Miller, would you like to provide a rebuttal argument?
Yes, Your Honor.
Thank you. Mr. Hickey, you may proceed.
Thank you, Your Honor. I will be very brief. Y'all heard enough this weekend today, especially from lawyers. Mr. Miller told you about reasonable care and that Rebecca has a duty of reasonable care. She read the words from her own mouth that she thought in her mind as her father was driving away in Suburban, knowing he had a pistol on the passenger seat. I really don't care what happens. She want to talk about reasonable care, she used the word care. I really don't care what happens. It's because she did. She didn't care. Her actions for the 3 years leading up to that prove that. We want to talk about the parking lot for a minute. Rosar's parking lot is not like a big Walmart Supercenter parking lot, but it is not a small parking lot. If I tell you I'm going to meet you in that parking lot, I'm going to at least do you the courtesy of telling you where I'm going to be, either up by the store or out by the entrance where you pull in and we have to run back to the parking lot. Or I'm going to tell you I'll be down by the library drop box. There were 2 people in the world at 5:45 p.m. on February 5th that knew the meeting was to take place at the library drop box at the end of that parking lot. That's Rebecca and John. But then a third person was told, James Brashear. You heard from the clips that he told Detective Crane that night, and I'm sorry, that was not a man that was out of it. That was a man that was calmly talking to a detective and almost proudly explaining what he had just done. And drinking water, he wasn't out of his mind. He was calm and fine with what he had done. He knew what the consequences were. You guys have been hit over the head with those guys. But he knew exactly where to go because she had told him. He was very clear he arrived before John. So it's not like he saw John, saw his vehicle, and decided that's where I need to go. He drove exactly where he knew that visitation change was supposed to take place. He knew exactly where John was. And it's because she told him right before he left. And again, she didn't really care what happened. This is my favorite picture of John. And this is what I am going to leave you with. Go back to December of 2017. That is when Rebecca took Shira and Zane and left Williston, North Dakota, and came down here under the false pretense that she was coming for a visit to see her parents, but ended up keeping them. John did not see his kids for another 9 months. He had to file for divorce in January of 2018, and the interim hearing, in Arkansas we call them temporary hearings. Let's go, let's sit, here's some evidence and see what we need to do until this divorce is final. I'm going to put some parameters on you. I'm going to figure out where these children need to be and where they need to be safe, that kind of thing. So they have this interim hearing in May of 2018 in Williston, North Dakota, and you're going to have that order back there. And that's where John got custody of these kids. That may have surprised you when you started to hear that. Wait a minute, he had custody? What happened? He got custody of the kids. The order was not entered, even though the hearing was in May of 2018. The order was not entered until August of 2018, the heat of August. And the order said John is to immediately have his children. So he drives here to Idaho, gets his children, and goes back to Williston. And if you remember the testimony, when I had Rebecca on the stand, I said, John had them for 5 days in that August before you started blowing up the phone to CPS in North Dakota to try to say he had done something to these kids. And she was proud. Yes, that's right. That's exactly what I did. And that's when the whole investigation went into high gear. And after 5 days of having these kids, CPS comes in and takes them out and puts them in foster care. This picture is from one of those days during those 5 days. That's what this picture is. And that's obviously a shower and saying, and that's John at his house. They would have you believe these children were so terrified of their father, they would not even be around. You can draw what you want from that picture. You might be questioning if I have my dates right because of what's behind John's left shoulder. That's a little Christmas tree.
Objection, how can we verify a date off of a Christmas tree?
You know what? I'll let the jury decide if they think that's a Christmas decoration.
Very good. All right.
Your Honor, can I ask a question, please?
Well, do you have an objection that you'd like
I
to
do
lodge?
have an objection.
What is it?
I feel like he's creating new evidence or it's bringing new evidence in. I thought we were done with that part of it. You can smile if you want, but that's my opinion.
It's an illustrative. It's not, this is not something this picture is not something that's going back to the jury. He's going to move on. So Mr. Hickey, I'll ask you to move on.
Thank you, Judge.
Thank you.
John had his children for 5 days in 2018, August. From that point on, it was supervised visitation, never could have them on his own, fighting court battles, allegations, as you've heard, investigations, all the way until December 2020, when the same judge that gave him interim temporary custody gave him joint custody, joint decision-making, and finally unsupervised time with his kids. He had them for those 5 days in August of 2018 unsupervised. Rebecca starts blowing up the phone in her family, going after him because they have lost control of his kids. The next time, he was supposed to have these children by himself and take them home and have a moment like this. The next time was February 5th, 2020. And we know what these two people do. These people are dangerous. Please hold them accountable. Thank you.
Thank you, Mr. Hickey. So, ladies and gentlemen, I'm now going to ask our clerk to draw a number between 1 and 13. The juror with the corresponding number is going to be dismissed at this time, but your service is not necessarily over. In the event that a juror becomes ill or is excused for any reason, the alternate will need to return and your deliberations will start again. And Madam Clerk, would you please draw a number? So juror number 4 is Ms. Van Horn. Thank you. We have a certificate for you. Looking for Dan. Well, let's see. We just need to make sure you leave us your phone number so we can get a hold of you. In the event that we need to get a hold of you, we will reach out. But in the meantime, you need to heed my admonition about not discussing this case with anybody else. Okay? We'll give you a moment to gather your things. I don't know, do you have something in the jury room that you need to get? Okay. I'll let you do that if you'll leave us with your phone number. We will do that again. Thank you for your patience. Appreciate you having here today and this week, actually. And again, I'm going to ask you to continue to abide by the admonitions about discussing the case or investigating the case until the trial's over. What we will do is we will make sure that somebody lets you know if the verdict has been reached, and that way we can release you from those obligations. Okay, thank you so much. All right. Madam Clerk, will you please administer the bailiff's oath as soon as he's back? Then before they do that, I just want to alert you, I've got a note that your lunch will be here at 11:30, which by my calculation is in 5 minutes. So we timed something well. So we got you. So we are going to provide you lunch so that you can start your deliberations. And then I guess while we're here, before we do that, ladies and gentlemen, what I'm going to do is once the jury is sent back to the jury room, I'm going to ask that we clear the courtroom to make sure that the jury has privacy. I think I've indicated to you that we're still figuring out the acoustics of this. And so when I send them back, I'm going to ask you to please gather your things in an orderly fashion. And you can wait here in the courthouse, but just not here in the courtroom. Okay? Release your Thank you very much. All right, Madam Clerk, if you would please administer the bailiff's oath.
Do you solemnly swear that you will keep this jury together in some convenient place until they have agreed upon a verdict, and not permit any communication to be made to them or make any yourself unless ordered by the court, other than to ask them whether they've agreed upon the verdict, that you will not communicate to any person the state of their deliberations or the verdict agreed upon until the verdict is rendered?
I will.
Thank you very much. All right. Ladies and gentlemen of the jury, the case is now in your hand. My bailiff is going to escort you to the jury room to begin your deliberations. Significantly, I am not going to read that instruction because now is the time for you to discuss the case. Please take the time that you need. And with that, ladies and gentlemen, please rise for the jury. Perfect. Time. Dan, I'll have you exit this way. I'll have you exit this way.
Okay, I'm just gonna,
Okay.
I'll figure it out.
I'll just make sure that since the bailiff's been sworn.
Gotcha.
Close it. It's fine. And I'll let you. All right, thank you. Please be seated. If we can, in an orderly fashion, I'll ask you to excuse yourselves from the courtroom. And we'll wait for the jury to put you on the original jury instructions.
And then.
Yeah. Well, we.
Yes.
Yeah.
No, you
What I'm saying is I can leave this live feed. Or do I need to stay on it too?
Yes.
So I need to stay on there.
No, he's saying as long as I'm going, you can.
I can leave,
Yeah,
okay.
don't end it, but you can.
I can get out of here. I can leave.
Yeah.
Oh, wait a minute, you better go this.
Testing, testing, 1, 2, 3.
Outside here. It's the loudest I've heard the speakers in here the whole time. Seriously. File.
All right, please.
Thank you. Good afternoon. Please be seated. All right. All right. We'll be back in session in Mast v. Brashear, Nez Perce County case CV 35-23-195. Mr. Brashear, Ms. Brashear, Mast are present at defense counsel table or defense table. Plaintiffs and their attorneys are all present at plaintiff's table. The jury is not present. Ladies and gentlemen, I have received notification that the jury has reached a verdict. Is there anything that we need to take up before we return the jury and take the verdict?
Not from the plaintiff, Your Honor.
Okay.
No, Your
Anything
Honor.
from the defense? All right. Please write for the jury. You may be seated. Thank you very much. The record will reflect that the jury has been returned. It appears that all are present and are properly seated. Madam Clerk, would you please take a roll call of the jury?
Trevor Price,
Here.
Ryan Sandin,
Here.
Brendan Lloyd.
Present.
Anton is not present. Brian Driscoll.
Here.
Michelle Pearson Smith. Here. Peter Wilson.
Here.
Janet Frazier. Here. Holly Carlin. Here. Leanne Liggett. Here. Jennifer Roger. Here. Jared Litchfield. Here. Christine Smith. Here.
Thank you. Will counsel and the parties stipulate the jury is properly seated?
Yes, Your Honor.
Yes, Your Honor.
Thank you. And Ms. Roger, now, I think I had a different name. I hope I'm calling by the right name.
I got married in October, so my last name is George.
Congratulations.
So I changed it with the office here, and I wrote George on all the paperwork.
All right, I appreciate it. Ms. George, you appear to have walked in with some paperwork. Are you the presiding juror?
Yes, sir.
All right. Has the jury reached the verdict?
Yes, sir.
All right. And would you please hand the verdict to my bailiff? Mr. Brescher, Ms. Brescher, Mask, I'm going to ask you to stand, and if you'll face the jury, please. And Madam Clerk, if you would please read the verdict.
In the District Court of the Second Judicial District of the State of Idaho and for the County of Nez Perce, case number CV 35-23-195. Robert J. Mast, Stephen R. Mast, Betty R. Troyer, and Michael W. Mast as the personal representative of the estate of John Mast versus James Robert Brashear and Rebecca Brashear Mast. We, the jury, answer the following questions presented to us as follows. Question number 1. Did the defendant Rebecca Brashear Mast commit an actionable wrong against the decedent John Mast that caused John Mast's death? Yes. Question number 2. What is the amount of damages the plaintiff Robert Mast is entitled to receive for the wrongful death of John Mast due to Rebecca Brashear Mast's wrongful act? Answer to question number 2. $1,350,000. Question number 3, what is the amount of damages to the plaintiff Robert Mast is entitled to receive for the wrongful death of John Mast due to James Brashear's wrongful act? $900,007. Question number 4, did James Brashear intentionally inflict emotional distress on Robert Mast? Yes. Question number 5, what is the amount of damages the plaintiff Robert Mast is entitled to receive for intentional infliction of emotional distress due to James Brashear's conduct? $50,000. Question number 6, did James Brashear intentionally inflict emotional distress on Stephen Mast? Yes. Question number 7, what is the amount of damages the plaintiff Stephen Mast is entitled to receive for intentional infliction of emotional distress due to James Brashear's conduct? $50,000. Did James Brashear intentionally inflict emotional distress on Betty Troyer? Yes. Question number 9, what is the amount of damages the plaintiff Betty Troyer is entitled to receive for intentional infliction of emotional distress due to James Brashear's conduct? $50,000. Question number 10, did Rebecca Brashear Mast intentionally inflict emotional distress on Robert Mast? Yes. Question number 11, what is the amount of damages the plaintiff Robert Mast is entitled to receive for intentional infliction of emotional distress due to Rebecca Brashear Mast's conduct? $50,000. Question number 12, did Rebecca Brashear Mast intentionally inflict emotional distress on Stephen Mast? Yes. Question number 13, what is the amount of damages the plaintiff Stephen Mast is entitled to receive for intentional infliction of emotional distress due to Rebecca Brashear Mast's conduct? $50,000. Question number 14, did Rebecca Brashear Mast intentionally inflict emotional distress on Betty Troyer? Yes. Question number 15, what is the amount of damages the plaintiff Betty Troyer is entitled to receive for intentional infliction of emotional distress due to Rebecca Brashear Mast's conduct? $50,000. Question number 16, did James Brashear negligently inflict emotional distress on Stephen Mast? Yes. Question number 17, what is the amount of damages the plaintiff Stephen Mast is entitled to receive for negligent infliction of emotional distress due to James Brashear's conduct? $25,000. Question number 18, did James Brashear negligently inflict emotional distress on Betty Troyer? Yes. Question number 19. What is the amount of damages the plaintiff, Betty Troyer, is entitled to receive for negligent infliction of emotional distress due to James Brashier's conduct? $25,000. Question number 20. Did Rebecca Brashier Mast negligently inflict emotional distress on Stephen Mast? Yes. Question number 21. What is the amount of damages the plaintiff, Stephen Mast, is entitled to receive for negligent infliction of emotional distress due to Rebecca Brashier Mast's conduct? $25,000. Question number 22. Did Rebecca Brashier Mast negligently inflict emotional distress on Betty Troyer? Yes. Question number 23. What is the amount of damages the plaintiff, Betty Troyer, is entitled to receive for negligent infliction of emotional distress due to Rebecca Brashier Mast's conduct? $25,000. Question number 24. Did defendant James Brashier kill John Mast by discharge of a firearm? Yes. Question number 25. What is the amount of damages the plaintiffs are entitled to receive because John Mast was killed by the discharge of any firearm? $100,000. Question number 26. Is plaintiff Robert Mast entitled to punitive damages for the defendant James Brashier's acts? Yes. Question number 27. What is the amount of punitive damages Robert Mast is entitled to receive based on James Brashier's acts? $500,000. Is plaintiff Stephen Mast, question number 28. Is plaintiff Stephen Mast entitled to punitive damages for the defendant James Brashier's acts? No. Question number 30. Is plaintiff Betty Troyer entitled to punitive damages for defendant James Brashier's acts? No. Question number 32. Is plaintiff Robert Mast entitled to punitive damages for the defendant Rebecca Brashier Mast's acts? Yes. Question number 33. What is the amount of punitive damages Robert Mast is entitled to receive based on Rebecca Brashier Mast's acts? $1 million. Question number 34. Is plaintiff Stephen Mast entitled to punitive damages for the defendant Rebecca Brashier Mast's acts? Yes. Question number 35. What is the amount of punitive damages Stephen Mast is entitled to receive based on Rebecca Brashier Mast's acts? $1 million. Question number 36. Is plaintiff Betty Troyer entitled to punitive damages for the defendant Rebecca Brashier Mast's acts? Yes. Question number 37. What is the amount of punitive damages Betty Troyer is entitled to receive based on the Rebecca Brashier Mast's acts? $1 million.
And thank you. I'm a person. I do see that the signature portion of the verdict form is not. I'm assuming that wasn't just overlooked on your part. Okay. I can have, or if you can return that to Madam Foreperson. To make sure. Thank Thank you very much. Ladies and gentlemen of the jury, is this your verdict? Right. Would any of the parties wish the jury to be polled? And you can please be seated. Go ahead.
Plaintiffs do not need the jury to be polled.
Ms. Brashear, Mast, or Mr. Brashear, would you wish the jury to be polled?
Can you define what being polled
I
means?
would ask them if this is their verdict.
No, Your Honor.
Okay, thank you very much. All right. Madam Clerk, I'm going to direct you to record the verdict. So, ladies and gentlemen, you have now completed your duties as jurors in this case. You're discharged with a sincere thanks to the court. The question may arise as to whether you may discuss this case with the attorneys or with anyone else. For your guidance, the court instructs you that whether you talk to the attorneys or to anyone else is entirely your own decision. It is proper for you to discuss this case if you want to, but you are not required to do so, and you may choose not to discuss the case with anyone at all. If you choose to talk to someone about this case, you may tell them as much or as little as you like about your deliberations or the facts that influence your decisions. If you decide to discuss this case with anyone, you should be careful to respect the privacy and feelings of your fellow jurors. You should limit your comments to your own perceptions and feelings. If anyone persists in discussing the case over your objections or becomes critical of your service, either before or after any discussion has begun, you may report it to me and I'll take appropriate action. With that, ladies and gentlemen, thank you. I appreciate your patience and attentiveness. I appreciate the attorneys for the professionalism, Mr. Brashear, Ms. Brashear-Mast, also for your presentation. I am going to excuse you now again with the thanks of the court. You're welcome to stay afterwards. Sometimes the attorneys and parties like to visit with you. It's certainly appropriate for you to do so at this point. But again, that's entirely up to you. The other thing I'm going to do is direct my bailiff and the clerk to collect your notes. Those will be destroyed. They'll remain private. Nobody will review those. So with that, I am going to adjourn this trial as the business before the court in this case has been concluded at this point. Again, thank you for your time. Appreciate it. And we'll be in recess.
It's like you end up top gun. You can always be able to do.
They gave it a song. She was one that's wrong. All that great. You were. I think whoever the sales, my mom. No running here.
Yeah. You did that. You deserve I told them, you said they sleep, so. I haven't there.
It's just that.
Yeah.
So that was pretty firm.
Yeah, a snake.
Thank you.